How long? Yes. All right. How many?
6 matters, sir.
We believe it's the last batch now. Yes.
Medical batch.
Medical admission. All right.
Your Lordship, kind leave, my
Ah.
that I filed a writ petition before your Lordship,
Ah.
and your Lordship directed the member secretary of the Pollution Control Board to file an affidavit by 29/9/2023, my lord.
Ah.
They have filed an affidavit that is matter is not listed on 29th, my lord.
What is the urgency?
My lord, the unofficial respondent is in spite of the notice issued by the HMD and the Gram Panchayat, and without obtaining the permission from the local authority, based on the consent letter issued by the Pollution Control Board, the unofficial respondent is going on constructing the ready mix unit, my lord.
All right. So 12/10.
My lord,
12. Today's what 10th? No, day after tomorrow. 12/10.
some of that.
Lordship, CRP is filed against amendment of the plaint in the lower courts, commercial court, Lordship. So, lower court,
When have you filed?
Lordship, in the last adjournment, the Honorable Court was ordered list after 3 weeks. So, but not listed it today. I'm requesting to list on
Just
tomorrow.
after 3 weeks. What is the urgency, mister?
Urgency means the lower court is insisting for the cross of the PW1, further cross of the PW1. Actually, my commencement of
What is
the
the date?
19/9, the Honorable Court, this Honorable
What is the next date before the commercial court?
tomorrow, Lordship. I'm requesting and listing it to tomorrow.
All right. 16/10.
Lordship, tomorrow I'm requesting them because lower court matters on tomorrow.
All right. Tomorrow. Yes.
Tomorrow, Lordship.
But why do you want I stay?
Sir, Lordship.
Stay of the proceeding. Why do you want the listing?
Yes,
you
yes,
should
yes,
at least know that.
In the last adjournment, Lordship, one of my colleagues wrong representation is done. That's the reason the Honorable Court in the last. Meantime, stay of the proceedings, Lordship.
So it was adjourned because you were not there, right? And now you are at your convenience, like play with this system whenever, like get the case listed, don't come. Why you did not argue last date? All right, tomorrow.
Your Lordships, my Lords, item 26, 27 and 28.
1 minute. You want to withdraw?
No, my Lords,
Then
I'm making a
wait.
mention here.
Wait, it will be called. Don't be under an impression that item number 26 won't be called. It will be called.
This
Yes.
Miller, the petitioner.
Yes. Heard on the question of admission. Note.
Second counsel.
We have given you the liberty to this thing personally serve, file proof of service. Pension.
I visited the college, my lord, but they are not ready to accept me, my lord. That is my endeavor.
Endeavor means you want us to punish them without serving notice,
No,
right?
I'm not
This can't be done.
Short date, my lord, because they are showing some other seat in place of my seat, my lord. That is my problem.
No, mister. What happens that you had come with the preparation that I have to mentally argue for half an hour, then only the court will. It has come effortlessly. So your mind is refusing to accept. Mister, the simple use, it is an open-ended thing. You serve it tomorrow, get a mention memo, get it listed day after tomorrow. It's a contempt. We cannot punish them without hearing them. This order, at least we won't do it. You may do it. You write an order, give it to them.
It's not so.
We can't do it.
Wait, not the second and third items are one way connected. Coming from a common judgment. Lord, I have made some dates for Lord's consideration.
No, 2-3 things, senior counsel. One is that the order dated 11/9/2013 passed in WP 26431 of 2013 was not challenged by you as soon as you came to know about it, and then you participated. Then that order subsequently challenged. Another thing is the order dated 29/10/2014 has been passed after conducting a detailed inquiry. Third is surrender of ownership rights wide order dated 27/11/1975 is in contravention of law, and the learned single judge has recorded a finding that it is non-est.
Well, I'll answer those.
Yes.
My lord, I'll purely put, my lord, make submissions in the light. My lord,
What are, yes, list of dates.
my lord,
Yes.
this case, my lord, for the first time, my lord, challenging an order of 1975, a representation was made to the collector in 2013. Then, my lord, the 2013 collector passes an order rejecting, that is the order dated 13/6/2013 in my list of dates, item 31, at page 150. Lord, this order, also kindly see at page 150, says that this representation is rejected. 150, order date 13/6/2013 at page 153, includes above findings, petition is not maintainable. Firstly, this is not a statutory procedure. Under Tenancy Act, there are two provisions, one an appeal and revision. This order of the DRO was in the form of a petition filed before the collector. Collector finds something, and says rejects this order. Then against this, instead of filing a writ petition or whatever revision, they make a representation on 17/6/2013 and file a writ petition at page 124. After the rejection, the writ appellant, who was a party, files a caveat. A writ petition is filed at item 34, which was disposed of on 10/9/2013, which is at page 124. See the prayer in 125.
Yes.
Now the prayer says, writ of mandamus declaring inaction of respondent number 2 in passing orders, representation dated 17/6/2013. So 13/6/2013 order, which went against them, against which caveat is filed, is avoided to be challenged, but only a representation made subsequently is challenged as a mandamus. The learned judge passes an order, and kindly see, the affidavit which is also filed there. Note page 134 of the writ affidavit. Very, my lord, appears to be a genuine representation, but my lord, an illegal representation. Page 134, paragraph 14. Fifth respondent herein filed caveat. My lord's got that. On the premise that my principles.
Which you are referring to para 15.
Para 14.
14. Yes.
Page 134.
Yes.
Fifth respondent herein filed a caveat on the premise that my principles would assail the correctness of the order in proceedings bearing number 13/6/2013 passed by joint collector. In fact, the joint collector dismissed the petition only on the ground of lack of jurisdiction. His observation with regard to my not having any proper power, in as much as power of attorney in my favor is unregistered and not even notarized, is contrary to the very document itself. There is no caveat with regard to the relief sought in the present writ petition. He is a GPA holder. His authority itself is in doubt. So he doesn't challenge the order which rejects the on merits. The contention of the 1975 order being challenged in 2013 was rejected. That was not challenged. And they filed a writ petition since they gave explanation with regard to why there is no need for a caveat to be served. Without serving caveat, writ petition was filed, making the writ appellant as fifth respondent, sixth respondent, and next day at admission stage, writ was disposed of. So, on this basis, the order is passed in 2014. Kindly see the order. Page 61. The order starts off, page 61. Well, I'll enumerate what are the all illegalities after I submit the facts. So, page 61, the collector starts with this case is remanded. So, my lord, he is under the impression that the order which he passed earlier was set aside and it is matters remanded for him to consider on merits. My lord, and this order is passed. My lord, I'll make out to Lordship, my lord, administrative law point without going to merits of the case. The Lordships have held, my lord, that in judicial review, we are only concerned with the process of coming to conclusion, not the merits. I will, my lord, submit my lord, submissions on that. One is, the joint collector initially did not exercise any statutory power. He entertained a petition and disposed of. My lord, be that as it may, that is on merits, saying that the order is proper. Then that is not challenged, it has become final. That is not challenged, it has become final. And my lord, a statutory authority like joint collector cannot review his own order unless statute provides for it. Lordship had so even in case of judicial power also, unless that power, except my lord CPC applies, line of cases where the authority where CPC applies, order 47 automatically applies, therefore review would be there. But an administrative authority to exercise a review and relook at a order, recall the order, specific statutory power should be there or a judicial order. Now the judicial
While
order,
this thing, while passing the subsequent order, this is what you say that it could not have review. Which order?
61 order, my lord,
No. This first order was the order dated 13/6/2020, 13.
yes.
Thereafter, the subsequent order in the year 2014 could not have been passed as it amounts to review,
Correct.
right? What is the date of that order?
This order
14.
is, my lord, 29/10/2014 order, according to me.
2910. Yes.
So, my lord, my submission is that, firstly, my lord, the entire process. Secondly, a little bit on, my lord, the entire proceedings. 1975 letter of proceedings cancelling, my lord, the 3080 certificate, whether it is a section 19, my lord, surrender or not, is what the learned single judge has gone into. Without going into, my lord, this process what I have submitted, the authority of the person who has passed the order on which a writ of certiorari is filed should be considered. That's not been considered. The learned judge goes through the merits of it. Lord, that's my first submission, Lord, that the judicial review is concerned with the process. The process is completely flawed, misrepresented. My lord, deliberately caveat is eliminated, and my lord,
All
because
right,
of that,
we'll issue notice. Yes, madam. Hold on the question of admission.
but a different writ petition
Hmm.
with regard to different land, different PT,
Same points, right?
but no different points. Because this writ petition, Lord, you kindly see, was filed in 2007. Not the prayer, Lord, you kindly see, is at page 19 of the paper book.
Hmm. So what are the submissions you tell us?
Yes,
Since
submission is that an order which was passed on 20th June 1978 is set aside in a writ petition of 2007 on the ground that the person who is supposed to be alive at that time was not served notice, and the death certificate of who died in 1979, death certificate of 2007 is relied upon by the learned single judge first time in the writ petition. And like a civil dispute, he gives a finding that the person was alive, therefore the order is not valid. So, without judicial review cannot make a finding of
learned
fact.
senior counsel
May I please?
Oh,
I may be permitted to please list of dates.
huh? Yes. The what list of dates?
Blood, in fact, not the apparent.
No, no, Mr. C. Some trust has filed some petition, right?
Seeking to implement.
No, no, not simply. Somebody has filed a writ petition. Somebody means. Wait,
He is a lesser, blood. He has a
you
lesser.
you don't know the facts of your case, Mister.
No, he is a not someone, blood.
Respondents number
Respond
one.
number one is the mirror.
1 minute.
Lesser.
Respondents number 1 and 2 have filed a writ petition, right?
Yes.
The prayer in the writ petition come to page 47. What is it? 47 of your paper book. Well, not ready, Mister.
No,
Not ready with the case. Huh?
yes, blood.
What is the prayer?
Writ of mandamus, any other appropriate writ order, directing the respondent to grant and issue essentiality certificate or not certificate,
Huh?
and all other permissions required for establishing a private.
So this thing from this prayer clause itself, it is evident that the petitioner in that writ petition intends to set up some educational institution. For that, he is seeking NOC, correct? Hmm? How are you concerned with this medical college? You also want to set up that very
No,
college?
no, no.
Then-
It's very petitioner in that writ petition where prayer started at page 47. Milady, he has executed a registered lease deed in favor of me for a period of 30 years.
Ah.
That lease is substituting. I have been running a college there. All essentiality certificate, NOC, permissions, affiliations were granted in my favor. But after successfully running for 4 academic years, he intended to start his own college. Therefore, Miller started making complaints to the authorities. Some of Miller authorities have issued proceedings Miller disaffiliating and derecognizing my institution. Those proceedings I had challenged before this honorable court, and this honorable suspended all those proceedings Miller. And those writ petitions are pending. Thereafter, Miller independently he filed a writ petition where Lars was referring to. There Miller he got a direction to consider his application for granting essentiality. That essentiality was
So what
rejected.
is your case? So it can't be considered even.
No, already an essentiality certificate is granted in my favor in respect of the very same premises, basing on the lease deed executed by him for a period of 30 years, registered lease deed. But a lease deed is subsisting, registered lease deed is subsisting in my favor. And basing on that, I obtained permissions and affiliations. Now, he approached the civil court seeking to cancel the lease deed. While the suit is pending, he approached the government seeking essentiality. Government rejected that. Writ petitions and civil suits are pending.
No, no. So supposing we want to know what happens if the essentiality certificate is granted.
The essentiality certificate is already granted in my favor in respect of the very same premises.
No, no. So what happens if it is granted? We are
That is
asking.
already rejected. Now he intend to impede himself in my writ petitions where I challenged all those.
No, no. We are asking for the consequence, Mister. What happens supposing essentially certificate is granted? What happens? Your certificate will not be cancelled.
Maybe Miller,
Maybe.
in the event of Miller granting that certificate, ultimately my certificate has to be cancelled. Miller, without cancelling, they could not grant that certificate also.
So you are apprehending that it will be cancelled without
No, reason is Miller.
Ah.
Now he has executed lease deed in my favor. He sought cancel he approached the civil court seeking to cancel that lease deed. That suit is pending. Now this essentiality certificate is rejected on the ground that civil suit is pending and writ petitions are pending in respect of the very same premises. No, therefore, Miller intend to impede himself in my writ petition, saying that now I independently seeking NOC, therefore my writ petition should be dismissed. Miller, and moreover, Miller, the writ petitions where this impugned order comes from, you will kindly appreciate that. I challenged only the proceedings of the university. It is not case of the
Learned counsel for the appellant submits that the of impleadment of a party to a litigation to avoid multiplicity of litigation,
No,
right? No,
here it is not the case.
no, no,
That
no.
I intend-
What we are generally as a principle of law, we are asking you, what is the object of impleadment? Is he a person whom you don't know and he is not concerned in any manner?
Exactly.
You are saying that he,
Insofar as this player in my writ petition is concerned, he has nothing to do with that. Because only Miller affiliation proceedings issued by the university, disaffiliation proceedings issued by the university were under challenge. It is not the case of the impleading petitioner.
no, the court has
without
said,
which role.
court has said that he is a proper party and it is necessary to do so.
It is not a necessary, court says Miller, it is
Proper
not a
party.
necessary party, but a
Ah.
proper party.
A proper party, nothing wrong with this. Order does not suffer from any jurisdictional
No,
infirmity.
your Lordship, kind of, Miller,
Right?
your Lordship, here.
I thought it has been rejected. Well, we thought it has been rejected, that's why we were issuing notice, sorry. Yes.
Miller, your Lordship, kindly hear me.
There's nothing
One minute,
wrong.
1 minute. Reason
No, nothing, no prejudice will be passed to you if he is heard in your petition, that's for sure.
Miller,
He cannot prevent you from arguing your own case.
No,
If he is heard, how can you object that nobody should be heard except me?
that's
Can
not my
this be
case.
the argument? Yes.
No, my case is that what is the locus of him to Miller get
Ah,
included in my case?
That we will answer in the order. Don't ask us questions. Yes.
I will leave it to my Lordship. Miller,
Nothing, there is nothing, mister. You also know it.
no, reason, your Lordship, kindly appreciate this.
This intra.
Miller, this writ petition is purely between me and the university.
Ah.
Miller, he, having executed
We
legal
will record your submission that he can't be heard and there is nothing to
No,
do with.
I'm not saying he can't be, I'm saying his implement itself is wrong.
Ah. So that's why he can't be heard. This is what you are saying.
Naturally, Miller, unless Miller, the matter settles in the civil court, he cannot be implemented. He has no locus to be implemented as a party.
You have entered into a lease with him.
Lease with him for a period of 30 years.
Ah.
That is a registered lease deed, which is existing as on today.
All. That's it. Anything else?
But the Lordship says,
Hey, this is not on merits, mister. This is only on an application for impleadment, right? This intra-court appeal has been filed against an order dated
recorded in the cause list. But I'm not holding the wakalat. I have given up, my lord, sir.
We have not heard you also, nothing.
That's-
The petition,
My
appeal is
name-
decided. It will never come again now. Yes.
Deeply obliged.
We didn't open to the petitioner to pursue remedies. This only not required.
The university may not file the
Ah.
appeal.
Ah,
Not punishment was imposed, my lord, for indulging in ragging activities. My lord, all of them, my lord, have, my lord, indulged in category 1 of the ragging activities, which are very, very heinous activities. My lord, your lordships are aware, my lord,
no, so what has the learned single judge has quashed?
my lord, the learned judge, my lord, says that, my lord, no punishment can be imposed. Some procedure, as if, my lord, it is a departmental or disciplinary inquiry against employees. The learned judge says that you have
But
not.
at least you must have given them notice, right?
No,
Did
in
you
fact,
give them
they
notice?
participated in the inquiry, my lord.
Okay.
They
So
participated in the.
what is the relief which is given to them? They appeared in the examination.
No, will your lordships kindly go to the
No,
impugned
what-
order?
My lord, from today examinations are commencing, my lord. They are not allowing the students, my lord. From today the examinations are commencing, my lord, and they are not allowing them.
Page 60.
We will consider this, allow them to appear in the examination, don't declare the result.
Okay.
Heard on the question of
Okay.
admission
Very
notice,
much obliged.
notice on behalf of respondent. You accept notice on behalf of everyone, right?
Yes,
Yes.
all the respondents.
In fact, my lord, if I am correct,
Yes.
the courts do say that in ragging, notice and
We will decide that. That's why we are. Madam. Admit. No, admit. Yes, to whom the seats are being allotted? You don't know. So, like it's like filing a petition asking the court to make a roving inquiry and to find out that who are the.
No, I've named all of them. I've given a
Please
list. my lord.
include at least representative capacity.
Yes,
How
page-
this can?
Page 102 is the list. my lord.
No, you have to include them at least some.
But there are thousands. I will not have one single detail of that particular candidate because it's an online process. I will not have
So
any
have you
detail.
demanded it from the university?
Time schedule, my lord. That's how, my lord. Thousands have
But
participated.
see, Mr. Rao,
But this is
you are intelligent enough to understand that we cannot grant
Yes,
leave
yes.
against persons who are not parties. What
I'm
you would have told Supreme Court that, sir, High Court has not appreciated that I am not a party and relief is granted against me.
I am conscious, my lord. But
Then
these are
this is
thousands and
conscious means
only-
this is good ground to dismiss the petition.
But this year, I have only identified a few of them. They'll be in
So
hundreds.
at least in representative capacity, impeach somebody, whatever, whosoever, whose name you like. How can we grant relief against the persons who are not? This allegation itself is unfounded that all candidates are being permitted to participate in the mock-up round who have been admitted in first, second, third round.
Kindly,
Please,
yes, see.
you please implead, mister. If you want us to proceed further, do it. At least in a representative capacity, some names, 2, 3, 4, 5, whatever.
My lord,
Two of them.
Before that, one small request, my lord. May I just draw your lordship's attention to the list? I'll impress on that fact that these many candidates on the
You
list.
want us, Mr. Rao, to pass an order?
No, I'll do that, my lord.
And please do it.
Yes, yes. I'll
Please do
just
it. We
kindly have
if
look
you
at-
do it today, we are ready to hear it tomorrow.
Kindly
We are
have-
aware. We are aware that it is a time sensitive matter. We
Yes,
are aware.
yes.
We are ready to take it up tomorrow. You do it today.
My lord, these details will not be available to anyone except the university. Except the university.
University, did you ask? For
Your lordship may direct, my lord, I'll implead.
There is not direct.
Tomorrow itself, I'll file an application to implead.
file.
Lordship may kindly direct them to provide all
You
the.
approach them. This is not the way. That file a petition, don't include necessary parties, then seek a direction from the court. We are not We are not seeking admission to this course.
Kindly
right?
see my
No, none of us.
representation.
No, none of us are seeking admission to this course. So why we will direct the university?
They could have as
You are
well
seeking.
admitted me, my lord. They could have as well admitted me. That's how it is so serious. Nobody, my lord, they did
All
not
right,
participate.
then we will pass an order. Then.
Kindly
If you are
see my
not listening,
representation,
if
kindly
you are
see.
not this thing, you are not prepared to implement. We will pass an order.
My lord, I will, my lord. Kindly see my representation, my lord, page 120. Page 120, I given a representation to the university, a very detailed one.
You implement. Mister, you furnish the particulars if he makes an application to you.
Just
To
one
do.
moment, my lord. I'll implement, my lord. I'll file an
So please
application
implement.
immediately.
We have orally told them also, Mister.
Yes.
You should implement first. Otherwise, we are ready with our order. If you are so fond of every time going to Delhi, please
Never,
go.
never,
We will not
never,
prevent.
never, never.
Then this the relief itself is see your relief, Mister. And you are intelligent enough to understand that you are claiming relief. The basis pleading is against those persons who are not parties. How can we entertain such a petition?
Very
We have told you, Mr. Supply them, if he makes an application today, supply him copies, the details of the persons, names, details you supply, you have it. You give an application today. Mr. P. Tirumala Rao, the Red Counsel for the petitioner.
Can you just give the allotment list, my lord? They'll know whom all I'm seeking, my lord.
So you give the name whom you want to implement, not thousand and
No,
this
I've
is.
already prepared a list. I've already filed it.
You,
My lord, I'll give it.
no, you want to include everybody in the list. Then what we are saying is, if you are interested in adjudication of the dispute and not interested in useless this thing formalities, then you better give a this thing application giving the details of persons to whom you want to implement. It may be 5, 6, 7, 8, whatever of your choice. If thousands of this thing, he will not be able to. If you are saying thousands of persons, then admit, then implement thousands of persons. We will issue notice to them, and you will know what will happen to your petition. Be realistic if you really want to. We want to help you if there is something wrong, but provided you learn to help yourself and not get into this.
Yes.
Give the names of persons like 3, 4. We are telling in representative capacity at least you implement.
Yes.
You are concerned with one seat or whatever seats. Implement those many people. So in case their admissions are set aside, you get in. Simple. If you want to complicate it, fine.
No,
Implement thousands of them.
No.
We will issue notice.
Just
Next
mention-
year we will hear.
just mention.
Next year. Yes. Same. Mr. Rao, same. Same. Yes.
Wait, please, Your Lordship. Because the matter arises under GST.
So
prayer
we have
manual-
passed similar order.
15 to see, there are similar orders at page 109, my lord.
100?
109, page 109.
Yes, this
My
page 109.
only- my only
Issue
addition-
notice list for analogous hearing along with WP number 25798 and 25810 of 2000.
Because the incident here was 317, madam.
Now 29.8.
The simplest circumstance, the order was passed on stage number.
Where is the order? All right, we'll admit it. Heard on the question of admission, learned counsel for the petitioner submits that the writ petition involving similar issue is already.
Maybe.
Madam 14, that SURFACE Act appeal lies. So Satyavati Tandon, what happens? You know, hey, we thought that the councils have stopped filing, still they file writ petition.
Kindly see the role of the petitioners.
No, nothing.
Either they are tenants or leaseholder. That petitioners are absolutely. They are
No,
the older owners of-
Section 14 is a different order. Section 14 against Section 14 and appeal this thing, remedy of under Section 17 lies. Go there. What is irrespective of the role, go there.
Kindly see.
Ah.
The special circumstances providing in this case is.
See the order. You don't practice in Hyderabad, right? Huh?
So
Hyderabad.
this matter is concerned.
No. See the order. It binds us. Irrespective of a role, this thing, obligation, role, whatever. This order binds us. If we are wrong, we have to be consistently wrong. This order so far has not been reversed by Supreme Court. So we are bound to follow. We cannot take a different view in your case. Please understand. When this order, every litigant same like you are appearing, so therefore we will not grant stay and put the officers of the bank behind bars. Right? Can't do it. Give that please order. This petition. Yes, anything you want to say, please go ahead. Huh? No, nothing, no meanwhile. No, nothing. This no, they go proceed ahead. This is in next 1 hour draft an appeal and go there. Today get it filed, get same thing.
The order passed by Chief Judicial, Chief Metropolitan Magistrate.
Is bad in law. Is bad in law. This is submission, right?
Not according to the province of service.
Yes. That is why Section 17.
Which is how it happened. Kindly see. Many petitioners are worthy original property holders. Kindly page number FIR also registered again in this principal debtors. Borrowers. Kindly special circumstances. Kindly see the gist of the FIR. Filed long back. Against these official respondents.
No, fact remains that you have taken the money from the bank and you are not paying it back and trying to content everything like whatever. So you are not guarantor also.
Yes, we are not guarantors.
Then you are tenants.
No,
So then how you are concerned?
Yes, that's the.
You are in occupation of a property which has been in respect of which a secured asset has been created in favor of the bank.
Kindly see page number 29. Internal page number 29.
You argue, Mr. What that 29, 39. This you are here to assist us, not to take us through pages. That we will do ourselves. 139. You are here to make submission. Please make submission. Why Satyavati Tandon should not be followed in your case? Tell us.
The petitioners are the original owners of the secured asset. In fact, they approached the official respondent number 3 and 4 before your lordships for loan. obtaining,
Yes.
for obtaining loan they approach.
Ah.
The third and fourth respondent, how they have cheated without saying in the FIR without lodged against those people, without because of the inadequacy and the illiteracy of the petitioners, without instead of mortgage deed, they obtained signatures on sale deed, registered sale. And immediately without after obtaining sale deed, immediately they approached the first and second respondent and borrowed for borrowing of money. Well, within 20 days. Meanwhile, they lodged a complaint before the police. After having known about the circumstances, the petitioners filed the FIR before concerned police. They gave notice also, police also gave notice to the reconstruction from the second petitioner, the secured creditor. The document find it out, the page number. Page number 27. Secured creditor in receipt of notice, in spite of it, after the run of 4 years, they made an application before the chief master.
You are arguing the matter on merits which is not permissible. You tell us, Mr. Why we should, under this thing, why we should not relegate you to remedy of section 17. Simple. You are arguing 4 years, 6 years, 25 years, whatever.
So far as section 17 is concerned, deals with two cases. The limited, the power of the jurisdictional power of the tribunal is limited to find out whether it is a tenant or occupant. Here is the case, neither we are tenants, nor we own the property as an occupant illegally.
You are a person aggrieved by the order passed under section 14.
Yes, section 14, I agree.
So therefore you can approach TRT. Simple, right? So what? You have a forum available. Three-judge bench of Supreme Court has deprecated the practice of entertaining writ petitions in the financial matters. Right? What can we do?
Of the order, Lordship, may kindly say.
Fine.
Order. The section 14 application was filed. Order was passed and appointing a commissioner to take question. Then application also not supported by an affidavit. As a simple bare application was filed. Without saying that under section 14 to take possession of the property. That's what my endeavor is Lordship, this honorable has ample jurisdiction.
Ample jurisdiction. To hang the officers of the bank. Ample jurisdiction to execute here at today itself 12 midnight. Yes. Ample jurisdiction. That's it. Hey, Mr. You should understand, right? Three-judge bench, Satyavati Tandon. Third time we are telling you, if you have not read it, go and read it. We are sure you must have read it. What is Satyavati Tandon? You know, like taking a chance like that. Let's see if the court. No, meanwhile, nothing. No. Let him be appointed. Very good. Yes, this petition has been filed. This petition. In this petition, the petitioner has asserted the validity of the order dated 20.
Represent
Yes.
1 and 2. Correspond number 3, Your Lordship.
This petition has been registered on the basis of communication addressed to this court. Per acre. If there is a more beneficial provision, that should be adopted whatsoever may, supposing if it is under that other scheme,
Yes, even that.
Prime Minister so and so scheme. So you do it. I mean, the object is to give more benefit to this thing,
Yes.
the farmers.
Two to 500 I am appearing. I am for respondent.
Notice on behalf. See how anticipation you are is like feeling. This rule nice or whatever you write.
I am for respond number 1.
Sure. Oh, what? Yes. This public interest litigation Yes. Ah, where is Commissioner? Ah, yes.
File report in the section, not an extra copy. We file status report in the section, not an extra copy also is.
Status report.
The lake, Milord, what
Ah.
action we have taken.
Now, what action has been taken to desilt and water holding? You know it, right?
Yes,
Ah, you come here and explain what action has been taken. Are you aware about the order dated 13th of September? What have you done? And why this order was initially not complied with when we were asked you to file a status report? What were you doing?
My apologies, sir. I recently took over as Commissioner at GHMC.
Huh?
I recently took over as Commissioner at GHMC, sir. My apologies. for
Recently
that.
means
3 months old.
this order
I can
was passed on 13/9/23.
39, sir.
Yes.
Yes.
After you had taken over.
Yes, 39 orders. So the first instance, the order is that we have to do the fencing of the land, of whole lakes. That is the first instance order.
Ah,
I said, what we have done is, 2016, the FTL
fencing done.
and
Fencing.
so
fencing
for the
done.
for the purpose of doing the fencing, the FTL has to be notified, sir.
Ah.
Your Honor, that for that purpose, we have returned to the.
FTL will never be notified, right?
So there's a process. FTL demarcation has been done, so that is completed, sir. We are now sent to the revenue department, and from there HMDA will notify the FTL, sir. So once that is done, we
Who
will take
appears
up
for
the fencing.
HMDA? You don't appear, right?
no, I am.
Huh? Where is Mr. Narasimha?
Seventh respondent. So we have actually conducted some encroachment removal drives. We have stopped dumping there inside.
No, Mr. There are, what are the directions? Are you aware?
Yes, sir. I have read
What
the
are the
directions.
directions?
So one is that desiltation of the lake has to be carried out.
What have
Water
you done?
storage. So for the purpose of desiltation, we have to fix the boundary of the lake, sir. That is the reason. FTL has to be fixed, then only we can take it up. Second thing is the whole land is.
Will be done by somebody else, so you have only written a letter and you
No,
are
FTL
feeling
demarcation, we
liberated,
have
right?
only done it, sir.
Emancipated, right? After writing a letter, they will, until they do it, we cannot do anything.
FTL demarcation, boundary fixing, we have already done, sir. We have the maps also, because GHMC only we have taken it up. It has to be notified. The whole thing is a patta land, not even an inch government land is there. This whole thing is a patta land. We have to now initiate process
What
of.
you have done? What have you done?
So the FTL demarcation is completed. We have written a letter to collector, so the collector, revenue department, they will give NOC
FTL
for that.
demarcation is done.
Yes,
You
sir.
have written when? You have written to collector.
2016 only the letter has been sent to the revenue department, sir. And then I have sent a reminder letter based on this letter, based on this order communicated to us.
You
on
want,
14th.
I mean, like 2-3 builders to occupy the lake and to come up with a commercial
The
complex,
whole thing
right?
is patta.
Huh? Mister,
Will verify, my lord, I'll file my counter.
hey, what is this 2016, mister? Can you hear him saying that
Yes.
2016 it has been sent? So what have you been doing?
Not received the report, my lord.
And see, they are very happy. Nothing can be done. We had sent a letter in 2016. Now, even if 2046, nothing is done. He can't do anything. He will retire in the mean. By 2046, he will retire.
Short adjournment, my lord. I'll
No,
file with
Mr.
instructions.
We will take a serious exception to this, mister. Who is the authority? You call him. Call him.
Fifth respondent.
Yes, well, Mr. 2016, don't behave like your councils, right? Don't behave like your, they also say 2016. 2016 has 365 days. When have you sent the communication? It has to be a specific date. On the basis of your statement, we are taking action against somebody. You have to be specific. Don't argue like your councils. They also argue like this, 2016. Date, when have you sent that? Mister, listen to one thing, Mister. FTL encroachment has been, FTL demarcation has been done, right?
Yes, sir. It has
When it has been done?
2000.
Again, 2000. Don't argue like your counsel. He also, don't feel inspired by him. Don't depend on him, otherwise he will ensure that you land in trouble. Don't depend on him. He also argues like this. When it has been done? FTL demarcation.
So I'll give the exact dates, sir. I'll
Who
get the
will
date.
give? Yes. Definitely. Yes. So when it has been done?
Sir, it has been done before 2016, sir. From 2016, we had
No,
already.
no,
submitted the
FTL
implementation report.
demarcation, when FTL demarcation has been done, Mister? Just now you said
Sir, I'll get the dates, sir, sure, because
you don't know.
based on 2013 order, we had done demarcation of all the FTLs in the GHMC area, sir. And part of a big exercise we have done.
This is like,
I'll get this.
this is like, you have been asked to appear in person. Definitely, we have not, this thing directed you to appear in person to see how you look like, right? Huh?
Sir, survey for
Sir,
survey notification for 2015.
You
the first
don't
survey.
know anything about the case?
Sir,
Don't know when it
2016,
has been done, 2013, 2016.
2016 December.
No, no,
we have submitted
this
the
will
reports.
entail Mr. a serious trouble. Don't take things lightly and don't depend on him. He cannot defend you. He himself doesn't know anything.
Sir, we have done the survey in.
You have no
2015.
other work but to attend the court. Come next time also. Now prepare, you tell us when FTL has been done, FTL survey demarcation when it has been done, and when you have written this thing to the revenue department to issue this notification. Then Mr. You better produce it on the next date of hearing instead of waiting for anything else.
Yes.
He will face the music for whatever he is doing, but you better come up with the notification that this has been fixed.
Yes.
Ask him what.
Yes. See, what have you done with respect to the mosquitoes menace, and there is also
Stray dogs.
stray
That will
dogs.
also depend on FTL
No, sir. We have
notification,
already
right?
taken so all anti-larval operations, cleaning up the lake, spraying and all we have already doing, sir, in that area.
Where are the particulars?
Sir, we have submitted that.
Have you done any permanent solutions for this? Because
Sir,
if
oil body release, kombucha fish release also we have done, sir, recently in the lake. All
Where
these
is it?
anti-larval operations.
Where is it? What have you
In the written
filed?
report we have filed, sir, in
What report, madam? Give.
page number 4, sir.
So this only a report, right, on the page, nothing done on the ground. This all.
Sir, it has been done. I personally
Ah.
visited the lake also at game, sir. We have done that.
This is Mr. 21/12/2016.
Yes, Lord. Even the
Then what have you done?
whether it has been notified or not,
No. Who has to notify?
the revenue department not have to take
No,
on
which officer of the revenue, chief
district collector.
secretary or
District
revenue
collector.
secretary will,
District
then we
collector.
will ask him to
R5.
appear, revenue secretary to appear.
R5, Lord, R5. District collector.
Mr. So two options, either he should issue the notification if not already issued or remain present on the next date along with this to give him company
Yes.
because he is feeling alone, right? His counsel is also not assisting him, so out of place. Collector will give him company on the next date of hearing.
Yes.
You have two options we are giving clearly. Either you come up with this fixation of FTL notification, you say, or he should appear.
Yes.
Two things, and he will definitely appear.
Sir, at page 9, you have also placed one, this thing, what you call, have you seen it? Don't throw garbage here. Ichata chetta veya radu. You have shown it, but have you cleaned it? What is the purpose of putting such flexis?
So we have cleaned it. So regular
It's
cleaning.
not
also
there
we
in
are
the
taking.
photograph. Please see page 9. First you are expected to do it, then put a flexi. Same again, go to page 24. In the photographs, it's very clear there is a lot of garbage accumulated. Though you have done fencing.
No, the husband, they will clean the garbage and then report further compliance next week.
By the next date of hearing, please file fresh photographs which corresponds to these photographs, stating that you have totally cleaned it, so that at least there will be some sort of your bona fide approach to this.
Yes, definitely.
So, Mr. Collector, which person, collector, which
Yes,
place?
R5. R5, Medsel Palkajgiri district. Now that the districts have been bifurcated, I'll inform the concerned district collector.
So, if he wants to see this heritage building, so he should come,
Yes,
or otherwise he can issue a notification.
yes.
Or if he wants to visit this heritage building, so let him come then. And you should clean, clean the garbage and should file fresh this thing. Take it seriously, Mr. That we are being nice to you, not shouting. That doesn't mean this order is capable of consequences, your appearance.
Sure,
right?
definitely.
And you can be placed, we can take action against you also. Direct the authorities to take action against you. Don't depend upon him. Don't think that if he tells you, no, nothing will happen, I will handle the court. He cannot handle the court. Right? That is the purpose of telling you and conveying seriousness. He don't go on his assurance. He is an advocate, nothing can happen to him. At the most, his enrollment can be cancelled if he is guilty of any misconduct. But you will face the music if you don't perform your public duty. We are telling very clearly to you.
Due respect, not in the first day itself, I informed them a lot, whether in writing.
No, that's why if they are not listening to you, that's why we have called.
Yes.
So you
Writing
will
and
instruct, if
seriousness of this honorable
this thing,
court.
and if it is not done, we will direct this thing. You are officer under which department? Revenue?
GHMs.
GHMs. Local body.
KED, local bodies.
Local body. Secretary local body can take action against him, right? If we direct.
Yes.
Huh?
And in this regarding the lake protection is concerned.
No. Who is the disciplinary authority? Chief Secretary.
President Secretary, Municipal Administration.
Chief Secretary. Yes, Chief Secretary. We will direct Chief Secretary, right? If any inaction is found on your part, we will this thing.
Actually, we have
And
taken
this is all this
initiative.
thing, Mr. for future generation, right?
Sorry,
It's
we have
not
taken a
this
lot of
other-
efforts in that lake also, sir. We'll definitely.
This is like mosquitoes, stray dogs, foul smell emanates from you not doing anything and saying that 3 months ago I have joined. What is this? And the very convenient 2016, we have written a letter. Whenever they respond, we will do it. It cannot be done. We will set him right also, Collector Medchal Malkajgiri. So, he has two options. Either
I'll con-
convey means
notify or-
either he has to notify or he will remain present in
Submission.
compliance of the order.
It's not the
Yes.
collector who can notify. It's one.
1 minute. Huh?
Regarding the lake protection is concerned, my lord. 3 authorities is, my lord. One is the HMD is the nodal officer and Commissioner and Irrigation.
No, we are not concerned. 3 authorities cannot issue notification jointly. This is Mr.
Altogether
Dom.
has to formulate, my lord, and they have to proceed further for fixing of the FTL and buffer zones, my lord. These 3 persons.
Then you tell us you are playing in a very proactive role. Why it has not been done so far? Why? Tell us. Whosoever has to do it, why he has not done it? File an affidavit. 3 authorities have to do it. Who has to do it according to you? Who will issue the notification, Mr.?
Irrigation department will fix the FTL boundaries and buffer zone boundaries, my lord. Then notification has to be issued by the concerned irrigation department in consultation with the nodal officer, that is HMDA, headed by the commissioner, my lord.
We will not spare, Mr. This. Don't you think that by complicating things by saying whatever orally, you file an affidavit? You appear for which department? So file an affidavit. And if any whosoever swears in an affidavit and makes a false affidavit, false statement on oath, which we find it to be false, you tell him that he will go to jail. He will not go home. Correct? Just like shifting burden, creating confusion, this is what preventing court from passing effective orders. This is what we are sorry to say that in a public interest litigation which pertains to preservation of time, your approach is like this. Sorry to say. File an affidavit. Don't try to confuse us. He is willing to comply. You are trying to tell him, no, don't comply.
We want to comply, my lord, with respect to.
You do it.
Yes, my lord.
That should be the approach. That, sir, this is the competent authority. I will see to it that the notification is placed before your lordship. This should be the approach. In a public interest litigation, don't this thing. Don't adopt an approach like this. That everything to be opposed. We will not spare your officers also. File an affidavit. Why he has not done it so far? Notification, no. That this all inaction, this people. Mister, you take it seriously, right? Better take it seriously. We will not tolerate this. The consequences will ensue. You appear for irrigation department. So who is the municipal administration?
Secretary Municipal Administration.
Secretary Municipal Administration. Responsible for anything, right?
Departments protect the lakes.
So let him file an affidavit what directions he has given with regard to protection of this lake. And why, if he has given, number one, if he has not given, why he has not done so. File an affidavit. We were initially concerned with protection of lake only, but you want the action to be your officers to be taken. So we will not hesitate. You want that the action should be taken against the Secretary Municipal Administration. So we will not this thing. We will not hesitate even for a moment. Don't worry. Or maybe you are generating litigation for them, asking them to go to Supreme Court so that now, sir, matter is sub judice, sir. What should be approach, Mr. in a public interest litigation? You tell us what should be approach. Constructive approach, is it not?
Within short period, my lord, within 4 weeks time, my lord, certain steps will be taken to notify this man.
Nothing, not 4 weeks. Nothing, we are directing next date. And he will face the music, don't worry. 4 weeks. This petition is pending since 2005. 18 years, you have not taken any action and you want 4 weeks time. For what? For going to this thing, Europe, to enjoy holidays. Your secretary. In compliance, don't, Mr. So long as we don't react, don't provoke us. You are doing unnecessarily. We were not asking you to say anything. He was undertaking that I will issue the notification. You jumped in. Now you face the music. We were not asking to proceed against, but you want action to be taken against. Good. That is like an officer of the court. That's how it should be. That you are against inefficient people. Inefficient officers. In compliance of the order dated 13/9/2023, what's his name, Mr.? Who is he? Commissioner of GHMC is present before. Why? What 2 weeks? No, no, no. See, why 2 weeks? Huh? No, what is the matter, Mr. Please? You have already filed another writ petition, right? In that writ petition, you can make an appropriate application. To that extent, we will modify the order. No, so order is passed. So what we will do in this writ appeal? Supposing if the order is passed today by learned single judge, what we should do? This subsequent writ petition you could not have filed. So what, once you have filed, you one after the other, you will keep on filing the writ petition. Why? There is something called res judicata, constructive res judicata, the plea. And this petition has been disposed of with the consent of the parties. Nothing. No, nothing. No senior. You are senior counsel. No problem. Tell him. Tell him. Tell him.
No. What is wrong with this order? Huh? We have already filed a writ petition. This is subsequent writ petition. And already the single judge has imposed cost of 5,000. Still you preferred the appeal.
In that writ petition,
And it was a consent order.
in that writ petition, interim order is there not to construct any construction in scheduled property interim order is there. But even that
So that writ petition is pending. So you pursue.
So construction, if it is in contra, what is the, then you also need an amicus curiae, right? To tell you what to do. Or should the court do, if tell you what interim order is violated, what should you do? This is not our job, Mr. Not the role of the judges that to tell you what are the consequences, what is your remedy. You are enrolled as an expert.
the content file both are
Nothing, Mr. There is nothing. Nothing. Yes. This intra-court appeal has been filed against an It is reserved since when? 2 years ago. It was reserved 2 years ago.
It is reserved from 19/7/2021. Last election, not single judge also city beside your
In a reserved matter, you can't move an application, right?
even
Fine. Yeah, we are not sitting here to convince you, Mr. The order is passed, the remedy is northwards. Travel.
also filed.
Copy. You want copy of the order? Copy. Yes. Next. Copy today. Yes. Next.
I beg to appear for the respond number 1, madam.
In this case,
This
Counter.
counter is filed by the respond number 1, madam.
Right.
In this case, the companies to dissolve by the order of the registrar of companies as on 21/7/2017, madam. But last time also you circulated this order, the petitioner had no right, there no jurisdiction status available to the petitioner to file the writ petition.
I beg to represent on behalf of C.H. Venkatraman, my lord.
Learned Counsel for Respondent number 1
Yes, my lord.
submits that by an order dated
These matters, my lords, insofar as WP 13321 of 2023, is I think 18.
what?
They're all connected
This has
matters.
been entertained, right? What counter pleadings are complete?
No, one.
Admitted for hearing.
One may not be required, my lords. What has happened is, I am before your lordships in a writ petition assailing an interim order of the enclave.
So you are
Final order has now been passed.
all right.
So maybe I have challenged it in an independent order. So your lordship may close my writ petition, leaving it open that these issues.
When final order?
The final order is passed on 17/8.
This writ petition, yes, with consent of the parties, same is heard. Finally, this in this writ petition. It has been decided, right? Appellate tribunal not decided.
Appellate tribunal, the order which closed is concerned, section 5 limitation was dismissed against which an appeal is filed. On the condition, 50%, the condo delay was to be allowed.
No. Mr. This debt recovery appellate tribunal has passed a final order, right?
No, not final order.
Not order.
Not for passed.
Not passed.
Not for passed a final order. The section 5 limitation was dismissed. That was carried back in appeal. The court passed an order saying that 50% to be deposited. Against that order, that petition is filed, subject to correction by London State.
May I now say?
Item 17 has been disposed of. It's his petition. You are in 18.
18.
17 and 19 would still remain.
Acha. So 18 is decided, Mr. 18
Yes,
you appear.
18.
All right, 18. 17, give 17. 17.
Election is 19 also. Let's take up 19.
My lords,
No, what happens to 17 has to be taken.
Same order. That is by same order. ARC has filed it. This is filed with auction purchase.
But same
Take up 17. Let's take 7.
17. So that order which, madam, that order was in item 18. 7. File an application for early hearing. When your synopsis is ready, we will consider. Yes. 20.
The matter arises under Telangana value added tax.
What happened to SLP? Still pending.
Still pending.
We will list it after SLP. Learned counsel for the parties jointly.
The Lordship, I am representing on behalf of Srinivas.
Teaching staff. On the question of admission, admit notice. So can we proceed from a stage for further of filing wakalat? Coming to the stage of instruction now. So have you been able to know whether you are contesting the claim of petitioner or not?
Milords, we have instructions saying we have already had a meeting with the MCC, Milords, Medical Council Committee, and we have instructions, Milords. I may pass on the instructions as well.
What instruction? You can't be told secret instructions, right? Which the court has to read. Otherwise, national integrity will be compromised, right?
Milords.
Huh?
Milords, we have been informed that the other two parties who have been interested to pursue the matters put off surrender.
Hey, what is it, madam? Say,
Milords, the other two parties.
you have to, will you not have to take a stand in the petition? Then
We are adhering, Milords. We will be taking them into the. We are adhering, Milords. We will be taking them into the.
taking them whom?
Milords, I may be permitted to read.
Unable to get it, madam. What is it?
Our grievance.
What is the stand of respond number 4? If you can tell us. If you can talk to your friend and let us know what is the stand of
They have
respond.
no objection to us being admitted because the round 3 candidates have already given an
So
undertaking.
then who is opposing your admission?
Nobody is opposing. In fact,
That
in
why they are not?
in lieu of the, if your lordship,
So your grievance was against respond number 4 only, right?
it was due to the inaction of respondent number 4, that respondent number 1 didn't issue us the admission.
Ah.
Now
then-
they have instructions from
Yes.
MCC.
That's a correct, madam. So forget, we travel beyond that. That's why you are standing here. No, now they will upload, so you will give admission. Yeah. Simple, madam.
Indeed, Milords.
You are unable to tell, think about what's wrong. Think about, you are a young person, that's why we are telling you that none of our business. But think when the court is asking, you should simply say that this is what has happened, but now we will do it. Simple. We are not contesting the claim, we will do it. This you could not say instructions, meeting and all this. And the result was that we had to ask her. You have to be quick, mentally quick. In this, yes, right. With consent of the taking, we don't know. They are not filing. They are saying that we don't have any objection. We have issued a direction to admit you to the course.
Obligement.
How they do it, it's their choice. They do it, madam. Why? This is not necessary, right?
Obligement. Same order.
Same order.
I think maybe.
Ma'am, please, my notes.
If I don't take the room, I won't be able to into practice. Yesterday,
Yes, sir.
Come to the court, we say what we do. You have the I expect that you take a bench and lift the instructions with respect to the way or not. But at least we did pull it off. So could you the city talk to me? We can take up a quote and something as we will take the quote in which matters we decide. That is plus we will be at a book for okay. How it depends upon cases are there. Yes, madam.
Ma'am, please, my lords. My lords, in this matter, my lords, we have given NOC to the petitioner, my lords.
Learned counsel for the petition.
Plaza, Your Lordship.
Prayer,
Non-considering the representation made by the petitioner and non-initiating remove the illegal toll plaza, check post on the river side, Paneru River, Your Lordship.
you decide the representation first at the first instance. Where is the removal of?
The contention prayer, Your Lordship.
Prayer is only to decide representation.
But there is no representation in the bill also, Your Lordship.
Non-considering the representation, no representation.
Page 35.
They also open files here only.
30.
Madam, don't
Affidavit and-
stop this habit of opening the file when the case is called, right?
Till
Do
40
some
page-
work at home also.
Till 40 pages, there is an affidavit, Your Lordship, in my writ petition. And after that, GO 38 is there.
Page 35.
Representation.
She has been told to take time for counter, like whatever told has to do. She is not open to this thing.
Affidavit is up to till
No,
page
to
40.
see for disposing representation, what counter is necessary.
For that,
Pass an order, that's it.
Your
Pass
Lordship,
an order.
dispose of, by consider, will consider the representation.
Then stop this habit of opening the file, madam, in the court itself. With the way you are turning pages, we can make out.
Stop to
Don't
40 page, there is an
be
affidavit,
ready.
that's all.
Please, all you are here to assist us. She has done her job.
But in our writ
Ah.
petition, the representation is not there. We
What?
consider the representation
The
sometime maybe.
prayer. You said that there is a prayer to remove the toll plaza. Without reading the prayer, you are saying that it is like that. Then we told you that it is direction is to decide representation. Prayer is to decide representation. You are saying representation is not made. We are telling you then representation is there. Should it take
Will
that
consider-
long? What is this?
Some time may be granted, Your Lordship, will consider the same.
Yes. So and so appears and submits that she has no instruction. Representative, how they will Yes.
Please, Your Lordship.
Yes, sir.
PIL, my lord, pertaining to, my lord, transfer of a toll operate transfer of Nehru Outer Ring Road. But for a period of 30 years, there are three contentions, my lord, in this PIL. One is.
No, this has to be heard, right?
Yeah, my lords, yeah.
Like you are.
My lords, in fact, today, the significant contributions made by the state, my lords, in the counter, it was not earlier counter.
No, have you filed the counter, everyone?
Today also, my additional counter.
And your lordship already granted interim or protected their interest. Now it should be heard finally, madam.
Additional counter is also filed today by them, my lord. I am in fact ready. Additional counter supports my case.
But we are not ready, right, to hear 23 petition and to forget about 2005 case. We are not ready for that.
Only point is, I will not the main matter.
All the
3 points.
learned counsel, who has filed additional counter?
My lords, the respondent government filed.
Learned Advocate General submits that an additional.
Counter, they clearly say that the loans taken for the project itself are of HMDA. But I
We'll
was
see.
simply asking if they cannot use the money, but they might have.
We'll see.
They should keep it in a fund separately.
We are sure that they must have something good to say about your antecedents and the purpose for which. Like this, it lighter vein, Mr. Not meaning anything.
Fundamentally, there is no public
I
interest
will,
at all.
yes. We'll hear it.
Yes,
Yes.
Obliged.
Yeah. 26 to 28. Now commercial appeals. Yes.
Item number 26, 27, 28. Your lordships take
You
together.
want to withdraw the amount?
No,
Why?
no, my lords. My lords, yes, there's an IA filed, your lordships, for the withdrawal of the rest of the amount, your lordships. There's a,
Remaining amount?
yes.
Why?
My lords, this IA, along with the main case, may be heard, my lords. We are the pleadings in this IA is done. Your lordships.
No,
the
what is your objection to permitting them to withdraw the amount? You have deposited.
I have deposited my part, your lordships. I have deposited 50%.
So they are not at flight risk. They have not taken loan from any bank, nationalized bank. They are not at flight risk, right?
My lords,
No, what is, that's why we have asked you, what is the ground to oppose the prayer for withdrawal?
my lords, I will file a counter
There
to
is
that IA.
not counter, Mr. There is an award passed in their favor. Please
No, my lords.
appreciate.
Yes. Awards was passed in their favor, your lordships. 50% of the amount awarded, we have deposited on the base of which we have got
So
an interim order.
that's why she is seeking to withdraw this amount.
Out of that, your lordships, the court already permitted them to withdraw 50% without furnishing any security. This IA which they are filing, your lordships, if I may put the figures, your lordships, the award was for 8.6 crores. Out of which 50% was deposited by us, your lordships, which is 4.3 crores. Out of which this honorable court had ordered them to withdraw 2 crores 50 lakhs without furnishing any security. That has been done, your lordship. They've withdrawn that amount. Now they are before your lordships to withdraw the rest 1.8 crores.
So let them withdraw. What is there? Subject to furnishing security to the satisfaction of the court, commercial court.
Your lordships may take it along with the main case.
No. What main case?
The IA, my lords, I'll file a counter in that IA also, my lords. When the
counter, Mr.
My lords, because there is no, my lords, the pleadings are done in this matter, your lordships. All three commercial court appeals may be taken up for hearing. That is my only plea, your lordships. The pleadings are done in this matter, my lords.
Pleading, there is no pleading in an appeal. What is the pleading in an appeal? Pleading is memo of appeal and copy of judgment.
My lords, I meant in terms of counters, rejoinders.
What is pleading?
Yes. My lords,
there is no question of pleading, Mr.
My lords may fix a date for hearing, your lordships.
And not decide this IA, right?
My lords,
because it's not convenient for you.
My lords, the IA may be considered with.
Heard on IA 1 of 2023. Heard on the question.
22, Your Lordships.
20th September.
Day of September 2022.
20?
20/09/2022.
20th September 2022 had permitted the respondent to.
Yes, Lordship.
Remaining cases IA is disposed of, then
Must oblige, Lordship.
Yeah, please.
Huh?
All citation melody is interstate transfers
Huh?
requesting 2 weeks time counter slots.
2 weeks he said that probably he has made a submission, it is covered by some judgment. Have you examined it?
Yes,
You said so.
Yes, Lord.
And did you examine it, Mr.? Which judgment, Mr. Krishna?
Lord, page number 134, Lord.
134. Yes.
Earlier occasion Millard is honorable court.
Huh?
Millard in this case, earlier Millard is pass orders Millard.
Huh?
Earlier occasions Millard.
Then? So he says that it is covered. So why not a similar order should be passed? That is the thing.
Yes.
Why should we should give you time?
My lord, I am appearing for respondents 3 and 4.
Huh?
We have no objection for the answering the petition. We get it. And request the government. The state government, Telangana Millard is
Has objection.
request
So,
Millard is.
so Andhra Pradesh has no objection in petitioner leaving. You have objection. So where he should go?
The falsification.
Petitioner should go to which place, Mister?
The falsification Millard is pending before the government lordships in this lordship. Can 2 weeks time Millard is whether this consideration lordship in this.
No, Mister. See.
Yes, the judgment Millard is I am not objection in this.
Then, if it is covered, then why you tell us why similar relief should not be granted to him? Simple. Tell us if it is. You understand, right? It's covered by this order passed in WP 582. Why it should not be, the benefit should not be given to petitioner? Simple.
By circulated Millard is the government pending before the government lordships.
I'm seeking direction to complete that exercise.
Huh?
I'm asked to complete that exercise. 2021, the state of AP sent Millard for consent. That too after Millard accepting both the governments. But entire thing is not pending the government for the last 1.5 years.
You do it, Mr.
That is Millard 7/10/2021. From that time Millard that is pending.
So your proposal for allocation to state of Telangana is pending.
Pending with the Millard state of Telangana.
Yes.
Andhra Pradesh accepted and sent.
You take action, Mr. We will, why to keep it pending? We'll dispose it off with, you take decision on this thing or within 4 weeks. Correct, Mr.
Yes, within reasonable time as your last.
4 weeks, reasonable time.
Yes, sir.
Yes, Mr. Mark the presence with consent of the
Please hear. I state the facts and then.
Next.
I prepared a synopsis of.
Please give it.
And very short matrix plot the entire cases. Lordship, so please I can.
Give us 5 minutes. We are.
Very well. Yes. There are two brothers, my lord, in respect of one particular land in survey number 27, which contained 14 acres. My lord, they divided amongst themselves, of course, under an unregistered document. One of the brother died. His wife, my lord, post coming into a legislation, agrarian legislation, namely the Agricultural Sealing Act. She files a declaration under that. In a sense, that document was acted upon by them. Under the declaration, she was found to be an excess holder. She surrenders 1 acre of my land as well. That was found fault even by the JC. Then, my lord, after 89 amendment, I go for regularization. But my regularization notice was issued to them, it was upheld. Then an appeal by them was unsuccessful. Then they carried the matter to the revisional court, namely the joint collector. The joint collector observed that how can you surrender their portion of the property under the excess land of the declared under the Urban Sealing Act, and says that government to take action. Perhaps that prompted them to file a writ petition. The learned judge says it is registration of an unregistered document of an agreement of sale. But so far as property devolution is concerned, by virtue of a settlement is also a transfer of interest. So therefore, it also rightly, I can understand, my lord, that no notice was given to them. They were not put on notice. And they say that this particular document is a forged or fabricated one. If that be so, they acted upon it. They filed a declaration under the sealing law. And if they say that it is forged, they did not do anything to substantiate that statement of forgery stated against this said document till now. That's the only issue. That's
My lord, single judge has rightly told, my lord, they are saying that partition deed cannot be regularized under section 5A Act. Section 5A of the Act, my lord. It's not a transfer, my lord. Only the partition between the brothers. It cannot be regularized under section 5A. My lord, I am relying on some judgments, my lord. Court officer. My lord, wherein this honorable court, my lord, referred in 2005 1 ALT 260, my lord. Previous law, my lord, wherein it was held that, my lord, it cannot be, partition deed cannot be regularized, and they have to approach the civil court, my lord, for getting the document. Right has to be decided, my lord. And basing on this judgment, my lord, para number 7, my lord, page number 12, para 7, my lord. As per subsection 1, section 5A of the Act, where a person is an occupant of by virtue of alienation or transfer made or affected otherwise than by a registered document, such alienation or transfer may apply to Mandal Revenue Officer for certificate declaring that such alienation or transfer is valid. In case of partition deed, there is no such alienation or transfer, but only adjustment of a right among the joint owners and co-sharers with the property. Further, under section 4 of the Act, any person acquiring property in inter alia, the partition has to apply to the Mandal Revenue Officer seeking amendment of the record of rights. For example, if the property is originally shown in the record of rights as belongs to the father, after the death of the father, his sons have to apply under section 4 and 5 of the Act for amendment of the record of rights. If there is a partition between them, therefore, the order of the Mandal Revenue Officer as well as Revenue Divisional Officer suffers from misdirection of law. A reference may also be made and made to section 8.2 of the Act, which stipulates that if any person is aggrieved as to any right by any entry made in any record of rights, he may institute a suit against any person denying or interested to deny his title for declaration under chapter 6 of the Specific Relief Act 1963. It is not denial that in proceedings before the mandal revenue officer initiated by late Anjaya, the fourth respondent raised dispute claiming exclusive right to the property in question. Such an event, Section 8(2) of the Act would attract, and as correctly observed by the Joint Collector, such question can be decided in cannot be decided in summary inquiry under the provisions of this Act. But under these provisions, whether the partition deed was executed by the partition deed has been taken between brothers or not, that cannot be decided in the court or the revenue courts. Title is in dispute, my lord. That has to be decided by a civil court, competent civil court.
So you are like relying on the same, like partition does not amount to transfer.
Yes, my lord. And AR 1988, Delhi 13, my lord. Para 12, my lord.
So all these authorities, they say the same thing, right?
Yes,
that
my
the
lord.
partition is not a transfer.
Yes, my lord.
But the contention which has been raised in this, have you got this?
No, my lord.
Give it to him. At least he should be able to meet it, right? Go through this. What?
Very good.
What do you say with regard to this partition is not a transfer?
Lord, the rights get extinguished and vest in some other person. That exactly that happened. And they acted upon that. They filed a declaration under the Agricultural Seeding Act. They showed that whatever fell to their share has given away excess. In addition to that, they have surrendered 1 acre of land of mine as well. So they acted upon it. Not that they have not acted. They can't blow hot and cold.
All right.
Subject law confirmation, my lord. Page number 24, my lord. AR 1966 Supreme Court 432. AR 1966 Supreme Court 432, my lord.
So these are all authorities, Mr. One is sufficient, right? Article 141, one judgment is sufficient. Are they different propositions or same that partition does not amount to
Partition in itself is not a title. That cannot be decided by the RDO. Any other artist. That has to be decided by the court of law.
Mister, you are relying on 8 decisions. We are asking whether it lays down the same proposition or different proposition. Then we will go.
Same only.
So then only one is sufficient. Why?
Regarding transaction, Lord.
What do you say about this? You have heard what senior counsel has said. That you have acted upon the settlement deed and it is not now open for you to say.
One thing, my lord. We are disputing the document, my lord, because my child's father died in the year 1967.
What? Don't say anything.
Yes, my lord.
They have acted upon.
So the document came into existence in 1968. Document came into existence in 68, my lord. Document where they are relying on the document, said document. The document came in the year 1968, and the respondent father husband died in the year 1967. We are disputing the document itself. That's why the land judge said you better attach to the lower civil court for adjudication, proper adjudication. That's all.
Yes, anything?
Only thing, not in the event if I'm putting something against me. Not in the event if the Honorable Court feels that I should be relegated to the civil court. There has been status quo right throughout. Please protect me till I go to the civil. In the event if it is against me. I'm grateful to you.
And then the proceedings before the executive. It will between the other things. Where else to be protected? You tell him English. Asking the question for senior point.
See,
Brother has a query.
Yes,
see, during the LRT proceedings,
yes.
inquiry was conducted.
Inquiry was conducted.
What was there in the inquiry?
In the net inquiry, so far as my share is concerned, I was well within the ceiling limit. So far as the share of 7 acres that fell to their share, they were found to be in excess because their other lands, they were asked to surrender. Under Rule 16, the Honorable Court knows that whatever choice is mine for surrendering, they choose to surrender what they got. They had to surrender 8 acres. They surrendered 1 acre extra, which fell to my share.
No, but the orders have been issued for both the brothers.
Yes, separately.
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 What was the extent? They have taken excess 1 acre from you and even from them.
No. I was not held to be a person having surplus land. I was well within the ceiling limit. They were held to be surplus holders. They had to surrender some land. They surrendered that 7 acres plus 1 acre of mine also. They had perhaps had to surrender 8 acres.
Understand that, but in the orders, have they taken a note of that? Because the inquiring officer will be one and same.
The verification officer would be one and the same. He must have taken inquiry, but I don't have those statements. If the Honorable Court, I'll ask my AOR to get those statements.
Civil suit on the ground that settlement deed is fabricated. Settlement deed has been acted on. So to be if they won't dispute, it's mention of the settlement deed. Yet contents are omitted, will be questioning the only issue for the partition the transfer of. It's clear, it is not a no rights of a only somebody easily used into the class. One more thing, it is a settlement, but big basis of partition is. Partition can be made right. It's can be will not be transferred, but still a possession. Still in case of settlement, parties are pushing the rights. Settlement. Any issue with the rights as a transfer. Settlement. If it is a settlement, it's a settlement. If a settlement means that it has to be registered. Settlement deed. It has to be registered. Believe it's not okay. Settlement deed acted upon by the party. So, have you admitted your signature, Mr., on this partition deed? Because this is the point which has been told, like.
No, madam, we are disputing that document itself.
Disputing document?
Because
Where?
My clients are.
How you have this thing, Mr., that round K you have said that they are not disputing?
Document cannot be seen, my lord.
They acted upon it. They filed a declaration.
No, my lord.
You said they do not dispute the signature of Kista Reddy on the document.
They never disputed anywhere.
He says a dispute.
Your lordship may kindly see the document for a second.
Ah,
There is no signature at all. We can't see the signature also.
where?
Please see the order of the joint collector. Please see the order of the RTO before the joint collector order. But kindly see the order of the joint collector.
Page number 48, my lord. No signature is can be seen.
Joint collector order. Joint collectors.
No, let's look.
Nothing, my lord. We can't see anything. It's a Xerox copy. And we can't see the signature also.
No, but where have you pointed out the process before the joint collector? Where have you said?
Main thing is, my lord. The lordship may kindly see, my lord, for a second. Page number 19, my lord.
Page 31 is the joint collector's order, which was challenged by them in the writ petition. Kindly see page 33. the penultimate paragraph onwards. As per the ROR Form 1, the total extent of the suit land is 14 acres, out of which 7 acres is claimed to have fallen to the share of the respondent herein. Late A. Kishta Reddy was the patedar. According to the original partition deed available, so-and-so, file number, 7 acres of land out of survey number 27 has fallen to the respondent herein, which has been regularized by the MRO by order under revision. It follows that 7 acres of land has fallen to both the appellate, together with the remaining 7 acres to the respondent, Srimati Sarojamma. The appellant too had filed a declaration under 8 of so-and-so act, which was numbered as so-and-so. In his declaration, there was no mention of disputed 27 situated so-and-so, nor it is computed to the holding of appellant number 2. Thus, the submission of the learned counsel for the appellants as suit land was declared and computed against the holding of the appellant is totally incorrect, misleading. The respondent also filed a declaration. In his declaration, the respondent has clearly declared 7 acres in survey number 27. This extent has also been computed to the holding of the respondent. The authorized officer of the land reforms branch has filed a detailed note in respect of the declarations filed by the appellant number 2 and the respondent herein. The detail furnished are appellant number 2, Srimati Saroja, filed declaration under 8 declaring survey number so-and-so, Situate village, survey number Situate, totaling 76 acres was declared as her holding. She was declared by the tribunal to have hold so-and-so standard holding in excess of the ceiling limits. She surrendered an extent of 8 acres in survey number 27 towards surplus land held by her and received compensation for the land so surrendered. Then, the learned, the joint collector in the last paragraph says, thus I am satisfied that appellant number 2, Srimati Saroja Ma, want only to avoid mention survey number 27 in her declaration, though she has 7 acres of share in the land. Then she was declared surplus. She cleverly surrendered 8 acres of land in survey number 27, though it was not declared by her. Thus, she also made fraud on the government to save surplus lands from being surrendered out of the lands.
See, page 47 and 48 are same.
That is handwritten, my lord.
But there are signatures, right? Same thing.
That is a handwritten, my lord. Neatly written copy.
47 is neatly written of 48.
That is not written.
Signatures are they?
No, my lord.
These are the signatures of the parties.
That's what I'm instructed.
They are the signatures.
Sorry, my lord.
No, you said this copy is not legible.
No, my lord. This is
Please wait. And you said that it's not, there is no signature.
Yes, your
Now we have verified at page 47, it is one and same.
Yeah,
Please
one
cite
thing.
by the parties.
When the
Whether the same parties or not.
my lord, one thing, my lord. This document where your lordship is seeing 48 is handwritten by in the year 94.
Yes. Please see the first word, first line itself. Asti vibhagapu parikattu kagitamu. Same, it starts with that.
That's right, my lord. I'm disputing only the document itself.
That's what we are asking. Is the document same?
Same document we are disputing.
It is not same. You said that there are no signatures.
In this original document,
the
your lordship may kindly see in the document in the 48, page number 48, there is no signature is visible.
Yes, sir. See page 47. There are two signatures. If the document is one and same, and it contains signatures,
sir,
what does it imply?
My lord, one thing, my lord. This cannot be the document of the same, because this has been handwritten again, and this into mark has been given. Krishna Reddy has been signed. That is not the original signature. We are disputing the document itself. That's why the learned judge not directed to go to civil court. And the core issue is whether the partition deed can be regularized under the 5A Act. And the 5A it cannot be done. partition date. There is no scope for a five-way inquiry.
Signature was not in dispute with the learned single judge. There was no dispute with regard to the signatures before the learned single judge.
Where have you disputed your signature, Mr. saying that not admitting in appeal is fine? But where have you said? Tell us.
Before MRO.
Which paragraph of the order passed by learned single judge? You are
They only said it is fourth, that's all.
Where?
Single judge order.
Page number 8, my lord.
Page number?
8, my lord, of the learned single judge order.
Ah. Yes.
The first respondent filed an application before the MRO Mandal Revenue Officer, fourth respondent.
Oh, where? Page 8.
Page 8, my lord, it's para 3, my lord.
Ah. This is first page. You are saying 8. Page 2.
Page 2, my lord.
Ah.
Third paragraph, my lord. He claimed through though he became absolute owner of that land, the relevant entries in the revenue record made in favor of the petitioner herein. He accordingly paid validation of the unregistered partition deed dated 14/2/1968 under section 5A of the AP Lands Particular Act of Short Act. The fourth respondent issued notice to the petitioner, though through his order dated so and so, not only validating the document but declared that the first respondent is rightful owner of 7 acres of land in survey number 27, which shall file an appeal and so on. So all this was recorded, my lord. Unregistered party indeed declaring the first respondent rightful owner of the property without jurisdiction with contrary to section 5A of the Act and rules made hereunder. He contended that 5A cannot be invoked to validate a deed of partition, since no transfer as such takes place under it. He placed reliance upon the judgment of so and so, so and so.
Not para 13, page 13, my lord, is the ultimate finding of the learned judge. Internal page 13, otherwise pagination wise page 19. From this, it becomes clear that the fourth respondent did not have the power to entertain an application for validation. Let the learned judge gives his reasons. No finding on forgery.
Your Lord, may kindly para 17. Your Lordship may kindly see page number 18, my lord, of the law of judgment, single judge. Para 20, my lord.
Yeah, unfortunately.
Declaratory.
That's not so it's.
O'Brien.
Yes, Mr. This thing to that extent, you will agree that in law that the learned single judge is right in holding that there is no question of granting any declaratory relief.
Declaratory relief that I am the owner, my lord, I never expect because I am a respondent in their writ petition.
Yes.
But I can't get a relief.
No, this order which was passed, fourth respondent. In
Yeah,
that, in
I
the
am a
internal page
respondent.
30.
I was a respondent in their writ petition. My lord, I cannot get a relief in their writ petition saying that I become automatically the owner.
No. But the authorities which had passed the order in your favor, they could not have granted this. See page 13. We are reading from page 13 of the order passed by. What you have to say this. Apart from validating the document, you just refer to this. We are reading that only. Page 13.
Page 13.
Yes.
In as much as the document.
No. Apart from validating the document. Please read apart from validating the document.
Internal page 13.
Internal page 13.
Very well. Apart from validating the document, the fourth respondent proceed to declare the first respondent herein as the absolute owner of the land. But he has, not the joint collector.
For that.
But I definitely concede that the joint collector cannot decide what the civil court has to decide.
That's what we said. I read further.
Even where the fourth respondent had power to validate a document, his function ceases with validation. But the issue before the joint collector was not as to who is the owner. The joint collector was not deciding as to who is the owner. The joint collector's consideration before him was limited whether what exercise the MRO and the RTO have done in exercise of the power under 5A was justifiable or not. Nothing beyond it.
But he has done it.
No, kindly see the order of the joint collector, my lord, which I just read.
The page?
Yes. It starts at, my lord, page 31 of the pagination.
Yes.
Kindly see the operative portion. At page 35 of the page name number, I also find that the learned revenue division officer Nagar Karnool, by order dated made in file number, has simply confirmed the order of the MRO so and so, where he regularized the partition deed without examining the above aspects. Though MRO has regularized the deed of the act to the extent of 7 acres out of total 14, the share of the respondent herein got reduced automatically by 1 acre, surrendered 8 acres. And the tribunal accepted such surrender and also surrendered by her so and so. In peculiar circumstances, the appeal is dismissed. The certificate in Form 13B and 13C issued shall however be restricted to 6 acres only. A copy of this order forwarded to the so and so to revise the computation of the holding of by adding 8 acres. That is what he has done. He has
And where is the order passed by this thing authority? Original order?
Original order.
13B and 13C certificates have been granted, regularizing the partition deed.
Revenue divisional officer is the order 71095, correct?
But this is 71095.
Next page.
This is an order by the appellate authorities order.
And where is the order passed by the original?
Original authorities order is 141194 at page 38.
Page 30, yes.
There was no declaration of title in my favor as such.
So what has been done?
It only thing is the what was given by the authority primary confirmed by the electoral authority was confirmed by the revision authority. And it said,
what is the order in your favor then?
Order of the primary authority, kindly see at page 38, last paragraph. Sri Parvat Reddy filed simple partition deed and the statement attesting witness have recorded neither Sarojama nor his son have adduced any material opposing the claim of Parvat Reddy. Parvat Reddy has also filed sealing declaration decision which reveals that 7 acres situated in so-and-so village fell to his share. In view of the above, it is decided that Parvat Rao is rightful person to hold 7 acres. As per the partition deed.
This order will virtually be highway. This is an order passed under 5A, right?
Yes.
What does 5A?
I extracted that in my note also in synopsis. No, I'll tell you a brief background of this, but if your lordship so please. Lord, there were two different set of revenue records being maintained when the state was composite, one separately for Telangana area, one separately for Andhra area. Then the state legislature thought that there should be one legislation for the entire territory of the state of Andhra Pradesh. That is how in 1971, this act has come whereby the maintenance of revenue records in the state was made equally same for all the regions.
So what is an order which can be passed under 5A?
That's what I'm saying, but I'm just coming. Then there was an amendment in the year 1989. This amendment introduced section 5A because by then, not all the agriculturists were obtaining loan on unregistered documents. Then the legislature thought that we'll regularize these documents so that it would become easy for recovery of the loans they have obtained and also for seeing that the documentation is perfect. That is how the statement of object of the 89 amendment reads.
May I mention,
One will hear. So what is the power, what is the order which can be passed under 5A?
Not to regularize an unregistered document, to validate it. After it is validated, my lord,
it becomes right.
After it is validated,
But there is no, this order says that he is in possession. It is decreased. Which is in contravention to the. So does it not declare your title, Mr. Page 39?
Page 39, it only says.
Rightful person to hold this thing means what does it? Page 39.
39 only he says, in view of the above, it is decided that so-and-so is the rightful person to hold 7 acres situate as per the simple part.
That is it?
I'm the right, in terms of the partition deed, I'm entitled to hold. That is what is the meaning, my lord, can be gathered.
No. 5A only regularizes the transaction.
He validates it.
But whereas at page 39, the MRO is declaring title. The tone and tenor of the order.
The MRO, but one cannot expect the MRO to have that legal acumen there. But ultimately, go by the joint collector's order. The joint collector never said anything with regard to the title. Because the document was acted upon.
So you agree that this he has no authority to declare title? No, 1 minute. So he has no authority to declare title and it's not a declaration of your
I can't venture to open my mouth before this court to say that barring for a civil court, no other person. I have to, I can't argue contrary to that.
Yes, yes. So we'll clarify the order to that extent. That it only, this thing regularizes the unregistered transaction. That's it.
But that also cannot be done. Your lordship, I kindly
that you have argued can't be done.
No, one thing.
Partition is not transfer and all that. We will.
Lordship, I kindly see the act, Lord, page number 11, Lord, of the 11 single digit order.
Can be done. No, we will be granting the liberty to the parties to agitate the issue with regard to title before civil court. The order is, has to conform to the mandate contained under 5A. 5A is, we are trying to understand, Mr. These are like, so 5A authorizes regularization of an unregistered transaction, correct?
Regulation of
Unregistered
transfer.
Unregistered deed of transfer,
Yes,
correct? Right?
Simple sale deed.
So, not only sale deed, but whatever is transfer. No,
Partition deed cannot be done.
forget, Mr. We are generally talking you. So, unregistered deed of transfer, correct? Now, your submission is you are going a step forward. That partition is not a transfer. You have given us 6 cases that we will deal with it. Whether it is a transfer or not, that we will decide. But so therefore, there cannot be any dispute that the order passed by the authority under 5A has to conform to the provisions of 5A. So 5A is to regularize the unregistered document, right?
Document regarding sale only, not against the partition. That's what my contention, my lord.
Mr. This is not sale.
Lordship, may kindly
Read 5A1, please read it.
Your lordship, page number 11, your lordship.
Please read first. Please read subsection 1 of section 5A. Please read. Let us first whether it says sale only. First you clear this thing.
The regulation of an alienation under section 5A of the Act is akin with the
Notwithstanding anything, read provision first. Let us first decide whether it pertains to. See, without reading the provision, don't argue. Don't.
well, notwithstanding the content in this act, the Transfer of Property Act 1882, the Registration Act 1908, or any other law for the time being in force, by virtue of any alienation or transfer.
So transfer is a word of wide import than sale. Sale is, you are such an experienced person, right? You understand the distinction between sale and transfer, or don't?
That has been
If you don't understand, then tell us. We will try to.
That has been decided in one judgment of this Delhi High Court. That's what I'm
Delhi High Court, Andhra Act, Land Passport Act, Delhi High Court decides.
One thing, regarding partition and the administration,
Doesn't understand, right?
but a second, your lordship may kindly see. Transfer of Property Act.
Please see the appellate court orders finding.
Partition of property.
The appellate, page 37. The Mandal Revenue Officer recorded the statements of the witnesses in the suit simple sale deed have admitted the lands was partitioned so and so. In the sealing declaration, shows
Which page which you are reading?
Page 37. That is the finding of the appellate authority.
37.
This is the Mandal Revenue has rightly decided the case, regularizing a simple partition by implementing the same in favor of the respondent. They were all parties to it. I see no reason to interfere. This is the appellate authority's order.
All right.
One thing,
What are the modes of transfer according to you?
Transfer only, is regarding
transfer in law. Forget about the case. Since you are arguing that it can be by way of sale deed only. All right, we will record your submission. It can be by way of sale deed only.
sale deed, simple sale deed, previously in the Telangana state, there is a simple sale deeds which are regularized by this 5A. And agreement of sale is not regularized. And there should be a simple sale deed, that can be done. Partition deed cannot be done.
That's a different thing.
That comes under 5A.
We are only trying to tell you transfer is a word of wider import than sale. Transfer has 5 modes. What are the 5 modes of transfer of property? Sale, gift, exchange, mortgage deed, right?
Gift.
And gift. These are the 5 modes. You are only trying to say it's only sale deed. We can't. In any case, we are not sitting here to convince you. That is none of our job. We thought that we were in the process of debating like an issue. That's why we told. We have understood that it can only be done by sale deed. and partition is not a sale deed, therefore.
That's a finding by the learned judge, my lord.
Fine. That we will decide. Anything else?
That's all. My lord, your lord.
Thank you. We will pass an order in this thing during lunch. You find out at 4 o'clock.
Very well.
It's being decided today.
Very well.
Or if you want that it should be dictated in your, we will do it at 2:30.
Oh, I leave.
We will.
Your Lordship's wisdom is your Lordship's wisdom.
Oh, thank you. All right, so.
I'm grateful to you.
Yes, it's disposed of, right? Send the file. And the Andhra Act, this Pattedar, whatever act. This send.
That act is now repealed in Telangana.
Yes. What you have quoted that act.
71 act is repealed in Telangana.
So this is disposed of item 30, right?
Very well, but I'm greatly obliged.
Huh? 18. 18.
Page number 31, Lordship, covered order, Lordship.
31.
CC today, Lordship.
Aha, today.
But
Page number 15.
Huh?
Page number 15, madam.
15.
Page number 22, madam.
22.
Page number 16, madam.
16.
Page number 16, your lordship.
All this certified copy today, right? Hmm.
Right.
My lord, I beg to appear in this matter.
Yes.
My lord, I beg to appear in this matter. This is an intra-court appeal filed by the unsuccessful petitioner. Am I audible to my lords?
Yes, yes.
My lord, this is an intra-court appeal by the unsuccessful petitioner, writ petitioner. And the subject matter of the case is that the writ petitioner is an industrial concern.
Yes.
The appellant, yes, my lord.
Agree by transferring. So what happened?
Well, the petitioner is a defaulter industrial concern insofar as the respondent State Finance Corporation is concerned. And therefore, under section 29, the unit was seized by the State Finance Corporation. Up to that moment, there is no difficulty, there is no complaint. The unit which is seized from the petitioner has been secretly handed over to the third respondent, which is a private party, without conduct of any sale or without any intimation to the petitioner. And for a very, very low paltry price is the writ petition allegation. The corporation did not file counter. The beneficiary of the corporation, third respondent, also did not file any counter affidavit before the learned single judge. The learned single judge has disposed of the writ petition, saying that the parties are at liberty to approach the civil court because there is no interim order in the writ petition all these years. And the auction must have been confirmed is what the learned single judge has recorded at internal page 3 of the judgment under appeal. Running page 7, internal page 3 of the judgment of the learned single judge. It reads like this: while admitting the writ petition, there was no interim order granted by the court, and having regard to the facts and circumstances of the case, and by effects of time, the auction sale conducted by respondents 1 and 2 in transferring the ownership of the unit in favor of the third respondent.
We have read it. So wow. There is no adjudication on merits.
There is no adjudication on merits, and then petitioner's case is that it is a secret transaction between the corporation and the third respondent, but none of them have responded to the writ petition, though the writ petition is of the year 1997.
But before transfer, any notice was issued?
No notice is issued is the contention raised by the petitioner, but not controverted because there is no counter affidavit. There is no appearance also of the second and third respondent before the learned single judge.
No, sir, but even on the second count, you have defaulted. First installment.
No, I am a defaulter. I have defaulted first count. Then my unit was seized. Then I made payment, my unit was given back to me. Second count also I have defaulted. I am admitting that I am a defaulter insofar as the loan amount to the corporation is concerned. But under section 29, the corporation's action must be in accordance with the provisions of law. And the Supreme Court, in number of cases, has held that it should be by way of auction and it cannot be by any other method. So
then we have to set aside this order and remit the matter to single judge.
Yes, that would be sufficient.
All right. Yes. This intra-court appeal is filed against an order dated 29th See whether it is amendment petition. Stage. Building permit has been cancelled. See what it has been allowed. What is the amendment they have made? Amendment, madam, what is amendment?
Yeah, please.
You are respondent.
I'm with appellate.
I'm for the third respondent.
Okay. There is already an order passed, you must be aware, right?
Yes.
Now they have filed a petition.
29th March 23.
Same pictures.
Ah.
Later on, it was
Now
third.
they have filed a petition for amendment.
Who?
If you respond,
That we will deal with you. Ah.
if your lordship is
Instead of this,
if your lordship is inclined to listen to take up that amendment petition, I may have to necessarily file a counter for that.
the choice is yours, madam. I mean, this Amendment, of course, inclined to means we will have to decide. Do we have an option of not deciding the application for amendment?
That's why I have to file a counter a lot.
Then say so. Oh, like what inclined and this, and you are waiting for this day, right? So whenever the petition would have been
was
called,
filed only last.
you would have. I mean, why when this application for
Was
amendment?
filed only last week, Your Lord.
So 10 days you could have passed and.
I know I have sent a word to the client, Your Lordship, and as the appellants, actual first appellant died. LRs, Your Lordship, they have called us. So 1 week time may be granted for filing counter.
Select Lordship's pleasure. My Lord, the amendment we sought for is actually the, I'm sorry, actually the
counter.
No, my Lord, her filing counter, etc. That may be Your Lordship may give.
That is fundamental right to file counter
Yes.
when it is called. It's not that on her own she will file. She will seek an adjournment. It's her fundamental right to seek adjournment and then file. What can be done?
We cannot
It's
have
not like that, Your Lordship. In fact, sir, filed on last Monday. I was-
You cannot, and it's this court can also write a fundamental right to seek adjournment cannot be defeated. She has, supposing if this case would have been called tomorrow, she would have tomorrow asked. She would not have said that I will file it, or she would not have until it is called and adjournment.
In fact, Your Lordship, this was
Learned counsel for the appellant praise warrant is granted a week's time to enable her. Ten days. 10 days.
I'm applying for respondent number 4 in this matter. Appearing to the petition.
You take care of this.
I'm appearing for the petitioner.
Ah.
The two petitioners, my lord. The present writ petition has been filed challenging the wires of certain provisions of the Petroleum and Minerals Pipeline Acquisition of Right of Users Act 1962. My lord, a little background for the case, my lords. There was a pipeline which was initiated by respondents 3 to 5, which is a Krishna Godavari Basin pipeline, which begins from Kakinada Basin and goes all the way to Gujarat. In the process, certain lands were acquired as a right of user. The petitioner's lands were affected and no compensation has been paid. I came on record recently by predecessor council challenge certain provisions. I'm also informed and I've seen that there are about 17 other applications, petitions also pending on the same issue. Well, my humble submission in all fairness, I would say is that this GO, in addition to the provisions that are challenged on the wires, the GO that has been impugned has already been put to force, and many of these where the right of users have been applied have been paid compensation. So far, the petitioners are concerned, my lord, compensation is still not yet paid. I am not getting into the wires of the law because this law had been in vogue for the last 6 decades. Because I just came on record a week ago, having seen this, sometimes a bad advice can creep in and petitions can get flying, they can lie over. In all fairness, I would only beg this honorable court that it can be heard and at least a direction for compensation may be paid. There are certain procedural violations because the notification that they issued, they did not follow their own rules in terms of putting me on notice and allowing me to get my compensation. Well, Lord, at this juncture, after a decade has been passed, I only beg this honorable court to direct them to pay us the compensation. That's all. I think rest of it is nothing in this writ petition.
Please, Your Lordship. My lord, here in the writ petition.
Not entitled to compensation also.
Compensation is given, my lord. Maybe my learned friend did not get instructions properly. Refused. We have the compensation. It is recorded that the DD is refused and it may be cancelled. Then the question, even before your lordship today, is not with respect to the compensation paid. Your lordship
That's what you have heard. You are saying not the question means.
Prayer, your lordship will see the prayer. They've only challenged the wires.
Can you not mold the, can he not mold the relief, mister? And this thing he has said fairly.
Yes.
So will you not even pay him compensation?
We're ready to pay, my lord. He has refused. His client.
My lord, they can pay it now, my lord. All I'm asking in this, my lord, one decade.
In all
another decade,
fairness,
15 years have passed.
In fact, the section 10(5) says if he has any objection with respect to the quantification, he has to go to the district court. Alternate remedy is available for that.
so first give him compensation, Mr. What you have adjudicated.
No, compensation is given, he has refused to take.
No, so therefore he cannot claim.
He can definitely claim.
Then-
We are not on the.
No, then if it comes to that, then we are issuing direction to you.
Yeah, no,
You cannot withhold, then return the land to him. If you don't want to pay compensation on the ground that once he had refused, what sort of an argument is this?
We have.
We are dealing with the constitutional right of a person under Article 3. You should say that, sir, he has refused, but we are willing to pay.
I've got instruction to that effect.
Then you are arguing that there is no prayer, nothing, this thing, once he has refused. What?
To the extent of this writ petition, my lord,
No,
but
no,
we are willing to pay, my lord. We have no objection to that extent. I've got instructions to that effect also.
There's nothing to argue, Mr. It's not that every case has to be opposed.
Yes.
Merely because he says, I mean, yes, you are respondent, therefore you have to oppose, nothing like that.
He has been fair to say, okay.
And this, that's why.
Yes. Make one more request, my lord.
Yeah.
Some interest may also be given, my lord.
Interest
That
means
I
now,
insist on
when
his
that's the
refusal.
problem. Then you can have, see, Mr. This they will make payment of compensation to you within 1 month. Thereafter, if you are aggrieved by the quantum, take recourse to the statutory forum. Which can, because that's a question of fact, which whether you denied or they paid, you refused to receive. All this, if we record, your statutory remedies will be closed.
I'm
Which we don't want.
requesting into protect. That's all, my lord.
That's what we are saying, that we are directing them to pay compensation thereupon under which section?
10(5).
10(5). What is the act?
It's at page,
My lord, the act is
32, my lord, page 32 of the petition.
The act is the petroleum and minerals.
All right. 10(5).
10(5), they can approach the district judge. And the compensation would be determined by the correctness
yes.
of the calculation.
Yes, they can approach.
That remedy.
All questions will be kept open.
Obliged.
Whatever. Right.
from the provisions of the act, since my friend was not arguing on that.
That I'm not getting because.
All right, so we will write that, this,
Because will not
consider
decide
the
impact on
submission made,
litigation.
we'll just record a line. Give that, consider the submission made on both, peruse the record, it is noteworthy that validity of the provisions of act has been upheld. No,
I'll give the numbers.
please give the numbers. So madam,
May I
make it
make one
listed
more request,
tomorrow.
my lord? There is a limitation which comes when determination of the compensation goes, my lord, which is under the provisions. That waiver, my lords, may direct, my lord.
So we have said it will be open and all questions are kept open.
That was never claimed.
Waiver, which is because they say 60 days or 10 days, I'll have to move. But the compensation is only coming to me now. Reckoning of the limitation is going to be an issue.
That will, you will argue that I have received compensation now.
My lords may observe, my lord, that because my lords have been kind enough
No,
to.
we have said that all contentions are kept open. Why to take away their right also? You can argue.
Very well.
Yes.
Oblige.
And other petitions, you are petitioner.
No, my lord. I came on board only 1 week ago.
Oh.
So I read the file and decided wires cannot be challenged. That call I think I'm duty bound to take.
Yes.
I'll inform the party.
Okay. Other petitions, you a number so that we can, if it can be decided like this, we'll take it up tomorrow.
One is board minute. The map. Claim of the petition minute has been settled minute by subsequently minute by paying the difference amount of rupees so and so minute to check minute on 7/5/2008. Therefore, minute no cause survives inspection minute.
Learned counsel for the petitioner submits that dismissed as infructuous.
My Lordships, I'm appearing on behalf of petitioners, my Lordship. This is the 2008 matter which was filed relating to price fixation. Nothing may survive in this writ petition right now, my Lordship.
Nothing survived. Oh. No, but why do you wait all the time? Supposing it would not have been called today, you would have waited, right? Why? It's not like this thing that you fixed deposit, if you keep it with you, it grows, right? You should assist, right? When the final hearing list was called, you should have said that item number has become infructuous. Supposing if we would have heard, we would be busy hearing some case. It would not have been called today. You would have never told us it does not survive.
It's fine.
Right? Learned counsel for the petitioner submits that nothing survives for adjudication in this writ petition on account of influx of time. What is it? What is it? What is it?
But this batch of cases will not arise out of the judgment, my lord, of the one single judge. Quashing, my lord, GO 32, which was impugned before the learned single judge. But confining the relief only to 103 my lord, members of the employees of the housing board. But on the ground, my lord, they stand on a different footing because they paid the differential amount. But I'll give the list of dates have been prepared, my lord. I think.
Brief submission or give?
Appeal has been filed by the government and housing board. Everyone.
Huh?
Everyone has filed an appeal.
Housing board filed the appeal and the government filed the appeals and ballot petitioners, writ petitioners have also filed.
The housing board is agreed by the fact that the single judge granted a benefit to some people. Those of us who did not get the benefits are agreed by the order of the artificial differentiation that the learned single judge brought in.
Let me refer to the list of dates which have been given by the appellants in 120.
Yes.
But GO2, but that was in 1991. But the 45 rupees per square yard was fixed, but depending upon the market value, but as then it was prevailing market value. This was the amount which was to be collected, but in 30 installments, and they collected from the salaries. Salaries every month, but they collected. After the collection, it has been increased to 116 by way of a resolution. Before we could pay the balance of the amount, difference of the amount between 116 and 45. But there was a decision saying that don't collect any amount because there is likely to be policy being changed. Then because of that, some of them could pay and some of them could not pay. 103 people have paid out of 320. But the GO 32 has been issued cancelling the earlier GO that is in 2006. That is virtually after 16 years, 15 years or 16 years after the first GO which has been issued. In between what has happened, some extent of the land which was originally thought it will be enough for accommodating all the 320 was found to be insufficient. Then Housing Board again returned to the government seeking the permission from them. They said it is for you to decide. You decide, extend the extent, because after all land is held by you. The land which has been acquired is held by you, so you can decide. Then they've increased the extent of the land. After increasing the extent of the land, they wanted to increase the payment 116. We were ready to pay, but they have stopped the collection. Having stopped the collection, the argument was out from the government and Housing Board is because the government has changed the policy, GO 32 is valid, which has been held to be by the learned single judge arbitrary. GO 32, which was under challenge before the learned single judge, was held to be valid. Our appeals are only to the limited extent, having held that the GO 32.
You are Housing Board.
No, I'm the writ petitioner. Our appeal is only to the limited extent, that having said that 32 is arbitrary, learned single judge ought not to have confined the relief to only 103 persons, those who have paid the differential amount between 116 and 45. Our contention is, the entire GO is liable to be struck down and all the employees who were promised originally and who were paid 45 at the rate of 45 rupees, are all entitled for the benefit of the learned single judge judgment. Our appeal is only limited to that extent. We have appeal, if Lordships look at there is a dichotomy has been made by the learned single judge among the petitioners, because such are those who have paid the full amount according to enhanced charges 116 per square yard, and such are those who have paid only 45. So that's how we get excluded because the appellants before your Lordships, those who are the petitioners, are only such of the appellants, those who could not get the benefit of the learned single judge judgment holding the GO, which is impugned as arbitrary. Because if your Lordship look at the conclusion at running page 43, para 25. Lordship got it, After going through the entire material, I am of the considered view GO 32 dated so and so is arbitrary to the extent of about 103 applicants who have paid the full amount as required by the respondent. Therefore, I am inclined to quiet the GO in part to the extent of eligible applicants who have paid the entire amount as required by the respondents, and the rest of the GO is held valid in respect to the applicants who are about 217 in number who failed to pay the full amount as prescribed by the respondent. But here, factually there is a mistake in the sense, not only 116, thereafter it has been enhanced to 204. I am not challenging relief which has been given to the 103 people. I am saying everybody is entitled. I may not be taken as if they are not entitled for the relief. But my submission to your Lordship is, But originally what was fixed is 45 rupees and we paid, everybody has paid 45. There is no dispute, my lord, because it was recovered from the salaries. When second time, my lord, when there was an enhancement that circular has been circulated in December, before we could pay, my lord, that doesn't say within what time we are required to pay. Before we could pay, my lord, certain people have paid before all others could pay. There was an order not to collect. So no fault can be attributed to the petitioners, my lord, such as the petitioners, those who are falling in 217, saying that you fail to pay that sum, you will not get the same relief as that of the 103 candidates. So that's how, my lord, my submission to lordship would be. It is not just at 116. Later it has been enhanced. There was a subcommittee appointed for looking into, and subcommittee recommended, my lord, and the cabinet approved that and said that it should be allotted to the members because they are waiting since long and they were the employees and retired also. So they are entitled for these allotments which have been given with reference to the plot numbers. It is not as though just a promise. Allotment letters have been given with reference to the plot numbers. Page 51, my lord, the list of the allotments, my lord, has been indicated. If you lord, page 61.
Totally, how many applicants were there?
What?
Totally, how many applicants were there?
320, my lord. 320, because as in the list of dates, my lord, as I have indicated, the very second date, my lord, list of dates says MIG, my lord, 115, LIG 181, and the economic weaker sections 24, my lord. In all, my lord, put together 320 plots.
So how many are covered under GOMS 32 and 2?
My lord, 2 covers all, my lord. GO 32 also covers all. Learned single judge quashed GO 32. And relief has been confined to only 103, my lord, people, those who have paid the full amount according to the learned single judge, which is, my lord, according to me, with great respect. That's where the learned single judge, my lord, went wrong. Confining the relief to only 103.
What was the amount prescribed in GOMS 2?
My lord, that is 45 rupees per square yard.
And 32?
But 32 is the cancellation of GO2, my lord. Okay. In between, my lord, various dates are there. My lord, 16 it has been enhanced. I will give you a lordship the date, my lord. 32 is total, my lord, cancellation of GO2.
Sorry for interrupting you. Under GO 32, what they did was, they came up and said, we are not going to give you plots, we are going to give you flats. After having given each one of them a determined plot number, by the impugned GO, the government said, we are not going to give you plots, we are going to give you flats.
16.
By then, out of 300 odd people, 1/3 had paid. The remaining 2/3 went to make the payment. Housing board said, and this is borne out by the admitted record saying, we are not taking the money from you because government has kept it pending. And then the judge goes about saying, those who have paid will get the plots, those who have not paid will not. Having found that if I can take your lordship after my friend finishes. Sorry.
Yes. My lord, one of the list of dates, my lord, 16/12/2000. Enhancement from 45, my lord, it has been enhanced to 116.
6.
Your lordship got it, my lord?
Page.
29/11/2000, my lord, there was a board meeting. I'm sorry. It's in the list of dates. Lordship got it, my lord?
Yes. Yes.
On 11/12/1995, the 29/11/2000 housing board meeting where it was resolved to register the plots charging at rupees 16 per square yard towards the cost and land under 100 per square yard towards the development. That is total 116. But letter has been issued on 16/12 basing on this resolution of the board. Letter second respondent wherein the allottees were asked to pay the difference. And in this letter, there is no deadline which has been fixed. In 2001, the instructions, 15th February 2001, instructions were given not to take any further action of collection, but that is how we could not pay. So this could not be a ground my lord, which can be picked up my lord, for confining the relief to only such a those who paid the differential amount. And in fact, my lord, later, my lord, your lordships may see on 14/12/2001 on the same my lord, list of dates, last but one my lord, date on 14/12, letter dated 14/12 by the vice chairman, housing board to the government, stating that the new rate is 204. The estimated cost of the land development of the government may take the necessary act. GOMS issued by the government constituting a cabinet committee comprising the revenue and finance and housing minister. Cabinet subcommittee recommended that the land already allotted to the employees of the housing board may be registered at the rate of 204 per square yard, including the development charge, and approved by the board subject to the condition if any increase in the development charge over and above 204 arises at the time of execution to be borne by the employer. So, not only at 116, it has gone up to 204, and cabinet subcommittee recommended it should be done at 204. If cost goes up, it should be again collected from the employees. So that's how, merely because the difference between 45 and 116 has not been paid by appellants like us, but they should not have been excluded from the relief being granted by the learned single judge is a limited point in our return. So it was not as though, and this cabinet subcommittee's recommendation has been approved by the cabinet also. All of a sudden, the reason is, in 2005 December, Vice Chairman Housing Commissioner has submitted a revised proposal with a request to cancel all the allotment to provide the houses in the proposed Hydernagar scheme. But may also now say, they were building the flats there in Hydernagar. GO 32 says that they will be allotted flats there in Hydernagar. Now, fact remains today, as of today, there is a status quo in the writ appeals file. So land which was supposed to be allotted to us and proposed to be allotted to us is intact. The Hydernagar where they wanted to construct the flats and give it to in lieu of plots, cancelling the scheme from GO 2 to GO 32. But that Hydernagar land is no more with the housing board. In fact, they sold it because we have obtained a right to information. We have subsequent to the filing of the writ appeal, we have filed the IA for taking the additional evidence that has been filed. Land in the Hydernagar where they are proposing to construct flats and allot flats instead of plots. It is no more available to the housing board, that has been already sold away. So that's how my submission to Lordship is, learned single judge having held rightly, saying that GO 32 is an arbitrary exercise, and one of the contention is this amounts to specific performance relief. But it has been held saying that no, this is challenging the arbitrary action. So that's how the learned single judge has come to the right conclusion, according to me, that GO 32, which has been challenged, is liable to be quashed on the ground of being arbitrary. But confining the relief to 103, only assuming that price variation, the price has not been paid by the others, but it has not been collected by the housing board, but everybody was willing to pay. In fact, there was a direction to stop collecting and acting in accordance with the decision to take the additional amount. Not only it stopped at 116, it has been increased to 204. And the subcommittee recommendation, your lordships have seen, it may go also forwards. So that has to be collected from them at the time of the registration, is the decision taken by the cabinet subcommittee, which has been approved by the cabinet. So that's how they could not have taken U-turn, and now saying that they will not be entitled to because they don't have any statutory right. They are like any other allottees. Once there is an allotment with reference to a particular plot at a particular cost, but vested right is created which should not have been taken away. And I need not elaborate that that they have to argue how the learned single judge judgment is wrong, so far as holding it to be arbitrary. So once it has been held to be arbitrary, it should have, relief should have been given to everybody, not confining to 103. That is that portion of the art I will challenge. So that's all my submission would be. Our writ appeals, challenging the order. The learned single judge confining it to only 103 members be allowed.
Which are the numbers?
Writ
appeal numbers?
Writ appeal numbers. my lord, 120. 121, my lord, items, my lord, 36, 37, 38, 41, 42, 43.
36, 36.
37, 38, 41, 42, 43. So far as our writ appeals are concerned. Where I am appealing also. Where I am instructed to appear, these are the writ appeals. There are some other writ appeals filed by the employees also, which is item number 46 and 47 also. First set of the writ appeals where I am instructed to appear. The second set 46 and 47 are filed by some other advocates. These are the appeals filed by the employees. The other one is filed by the government, one is filed by the housing board.
May please. I appear in item 46, my lords, which would be writ appeal 474 of 2009. May I formally first adopt all the arguments of Mr. Prakash Reddy. In addition, may I kindly draw your lordship's attention to the rationale of the learned single judge, which your lordship would find at para 21 of the order of the judgment under appeal. It will be internal page 28 of the learned single judge's order, paragraph 21. May I read, my lords? Yes. In the circumstances of the present case indicate that the respondents made up their mind to give plots to the petitioners. Rates were also revised from time to time. Plots were also identified to the applicants. 103 people admittedly paid the full amount as required by the housing board. Just before the registration of the sale deeds, it struck to the respondents that they cannot lose valuable land for the sake of employees. There was a hike in prices due to delay in registering the plots in favor of the applicants. It is nothing but normal that prices continue to increase, and when delay is caused in taking a decision, it pricks the mind of the officers that they are giving away lands for paltry amount when the prevailing rates are very high. But the officers fail to take note of the fact that the government fixed the rate by taking into consideration the then prevailing rates as of the date of taking decision. If the decision is implemented immediately, the properties would have been registered in the names of the respective applicants without a problem of comparing the rates prevailing then and the present. On account of the delay in decision making, the applicant shall not be made to suffer, at least those who scrupulously followed the instructions of the respondents and parted with money. Pausing here for a minute, this at least those who scrupulously followed is a new classification that the single judge introduces into the rationale of his writ petition. The admitted case of the housing board is that after the revision was made, everybody was willing to pay the money. However, after the beneficiaries of the single judge's judgment had paid, they had called stop, and therefore we did not pay. I can even go to the extent of saying maybe the judge was right in saying you were given an opportunity, you did not pay, so pay the price. That was not the case of anybody. Their case is, while we collected the money from 100 odd people, we did not collect it from the rest, not because they were not ready, but because government asked us not to collect. So this whole artificial creation of a new category of people by the learned single judge, excluding 200 odd people from the 300 beneficiaries, would be discriminatory in new way. Next paragraph. The GO was issued on 10/1/1991. After 16 years, the impugned GO has been issued after flowing of much water from the date of the earlier GO. For the administrative lapses or delays, the applicants cannot be made to suffer. That applies to everyone. When they fulfilled all the conditions, they legitimately expect that they would get the benefit. Had they been given the land by executing the registered sale deeds, they would have made constructions long ago, would have comfortably lived all that. The impugned GO was issued only on the ground that on account of escalation of prices, it was not desirable to part with the land to the employees who have no statutory right of allotment. But the orders issued by the respondents from time to time indicate there was a practice of the housing board allotting plots to employees even previously. The board favorably considered the representation of the new set of employees for similar benefits of allotments. Had the board felt that there was no statutory right, it would have outright rejected the applications by saying that the board is not inclined to recommend to the government for allotment of house sites to the employees. Having recommended favorably, having obtained the GO from the government for allotment of lands, having fixed the rate, having collected the amount by deducting the installments from the salaries of the respective applicants, it is not just and proper on the part of the respondents to go back by taking the excuse that the applicants have no right under the statute for allotment. Once this argument comes in, there could not have been a further classification between the two categories. I rest.
In matters like this coming, we can use the countries, basically even the rate that 2023. Become the total resolution which is landscape, daily calculation can be disclosed of this at this belated stage. Still enter into in one matter by the
I'm sorry, my lord.
Very 230, 244. They say reality. 63. This is the
Lordship's leave it. This one aspect I wanted to bring to your lordship's notice. I'm sorry. We filed again 2 of 2020.
it's too needful. Actually, they will be making maybe double level principle. This has a possibility of this issue because everybody will impact the benefit of disorder presently. That is so. We are saying since the issue has been resolved, we are saying that they were willing to pay. The government itself said that on 15 to that we would not accept this. But that's why to the good fresh and they pay a total rate. Time was more. It is right. We have to give it promissory instructions. But to conclude the transaction, what is the amount due to the government? Then why they should suffer? They have been made to litigate. They have filed the petition. They are pending decided in their favor. Spending time is okay. But people refuse this. Even too much for even if it is that's like when given this there. You need to put a pointer. What could be the value of this property per yard as of now?
Some crores. Some crores today. This is the extent of land in Kukatpally.
Is there a possibility to work out on some figure? Because at this belated stage,
I just wanted to bring to your lordship one factor I wanted to bring.
we are only exploring a possibility for an early settlement.
I understand.
May I put it this way?
Because in one matters, I did it. So we can extend the same thought process.
Only one.
Already the rights have been created. Only the issue is now confined to the quantum. some people were given the benefit of the GO, some were not given. It is a
No,
total.
learned single judge Mulad made the, Mulad, as I said, Mulad, while holding the GO 32, which was under challenge, is arbitrary. Learned single judge made a dichotomy, Mulad, between 103 and 217, which is, Mulad, in the sense, Mulad, artificial, because 217 were never, Mulad, as if they were not willing to pay. Willing to pay, but there were orders not to collect.
In fact, my lords, that's what I wanted to
But
bring
we
to your
stand on the same footing. We stand on the same footing, Mulad, so far as arbitrariness is concerned. But now that, Mulad, the price is going up, but your lordships will see, Mulad, as it has been put to the right single judge. If they would have acted, Mulad, immediately, Mulad, prices would have been. Mulad,
The question is now how much, what could be the possible quantum per yard? Who decides it?
My knee-jerk is unimaginable for them.
Mulad, may I say this?
Unimaginable
No,
for them.
Mulad, may I say this? Mulad, I'll put it, Mulad, subject to what your lordship say. Cabinet has also approved, Mulad, accepting the recommendation saying that 204, but if it goes up, Mulad, if they have to develop and give it now. And housing board ultimately it has to give, Mulad, what numbers have been given, they have to develop and give. If it goes up, Mulad, development cost goes up. But they can certainly collect from the employees. That is what has been said, Mulad, even in the cabinet subcommittee decision, Mulad, which has been referred by me. But that will not be known. They can't calculate the value of the land going up, Mulad.
Together, single judges creating the distinction. Why they should separate if we agree that it should be.
Mulad, may, sorry for repetition, Mulad, may I just bring to your lordship's notice list of dates at page 3 top.
No, you have told us that
Yes.
you
So the cabinet said
15th February 2001.
Yes, Mulad, that is, no, Mulad, not that one, Mulad, 22nd July 2003. Page 3 at the top. Cabinet subcommittee recommended the land already allotted to the employees may be registered at the rate of 20 per square yard, including the development charges, as approved by the board, subject to the condition that if any increase in the development charge over and above 204 at this execution to be borne by the employees. So far as the development charges are concerned, if because of the lapse of time, Mulad, if it goes up, necessarily employees have to be paid. But the value of the land today cannot be taken, Mulad, as if it is their land and we are being benefited. We have been deprived of it for all these years. But as early, Mulad, this GO2, which is the basis for our pension that we are entitled to, is 1991. So almost, Mulad, now 32 years. 32. They can't come, Mulad, now say that 32 years value has gone up. Property, in fact, was allotted to us. We have given the list of the allotments also. We have been deprived of enjoyment of that land, Mulad, so far. Development charges, yes, Mulad, because of the litigation and because of the pendency, the development charges goes up, Mulad, asking the employees to be paid is all right. But present market value cannot be the basis, Mulad, for a decision making is my submission.
Can't be.
Yes, that is my submission.
Just two aspects I wanted, I forgot to bring it. We filed IA 2 of 2021 in 474. In that, your lordship would find that document dated 15/2/2001, where court of IA2. IA2 and 474. Your lordship may kindly peruse page 10. This emanates from the chairman, vice chairman of the House and Housing Commissioner. He says, please refer to the board resolution of Jan 2001 with regard to registration of plots in the names of the board employees. Principal Secretary to the Government Housing Department has talked to me over phone that the matter is under examination by the government. I therefore request you that no further action is taken until further orders. So we will start from paying the monies. This. And then, my lords, come to page 25. Page 20. 23. I beg your pardon, 24. Is a recommendation by the vice chairman starts at page 25 actually, 15/3/2013. Housing Board writes to the government the recommendation your lordship would find at the last page of that communication, which runs into up to page 33. Kindly come to page 23. In view of the above, the government is requested to issue necessary orders to withdraw the writ appeals as filed by the, and since all the 320 have paid more than the land cost long back as per the board resolution, to ask all 320 to pay the difference of balance development costs, which may be calculated as per the present estimates to get their plots registered. Now, this is the recommendation moving from the Housing Board as late as on 15/3/2013. Kindly come to the next page. 6 years down the line, they have the same approach. 6/6/2018. Come to the last part of the communication. Your lordship would find this at page 41. In view of the circumstances explained above, the government may please to take suitable decision on the request for physical possession as provided under so and so, to register, confirm under rule so and so, to register plots, considering all the allottees have paid the amount as prescribed in GO2 at 45, which is more than enhanced land cost of rupees so and so. The difference amount between actual and development cost already paid is so and so percent. So it's also the recommendation of the Housing Board from time to time that the land should come to the petition.
Item number 47. My senior has logged in virtually. Item number 47, writ appeal 525 of 2009.
Item?
Pass on the list of events.
Item
number 47.
You are employee
Yes.
or what is a Housing Board?
Yes. Writ appeal 525 of 2019. Item number 40.
You are appearing for employees.
Yes. Yes.
47.
Yes. My senior has logged in virtually.
Not there.
Yes. There appears to be some network issue. Milord, he has logged in.
Not, we can't see him either or hear him. What to do? So you tell what is.
Is there?
Mr. Reddy.
Yes, Milord.
Manohar Reddy.
So far as the appeals are concerned,
Yes.
like adopting the arguments advanced by Prakash Reddy and Ravichandra. Your lordships are aware the doctrine of legitimate expectation will apply. Insofar as this case is concerned, GIVO was issued in the year 1991. The entire amount of the land cost of rupees 45 has been collected. Only insofar as the development charges are concerned, that was referred to the government. I am referring to to the constitutional bench judgment of the Supreme Court. Insofar as with regard to the legitimate expectation which is reported in 2023 SCC online, Supreme Court page 994, where insofar as with regard to the employees are concerned, phase 1, phase 2 and phase 3, lands have been allotted by the Housing Board after collecting the cost of the land and the development charges. Insofar as the appellants here are concerned, they are employees with the Housing Board in the 4th phase. Similar benefit is being extended. Insofar as the 4th phase employees are also concerned, they are also entitled for the same benefit. There was a legitimate expectation insofar as with regard to the appellants here are concerned, that they would be allotted the lands and the price which has been collected. If a lordship can see the latest judgment of the Constitution bench, dated that is 2023 Supreme Court cases online, Supreme Court 994. This matter arose with regard to.
This is Kerala Higher Judicial Service Special Rules.
No, because I'm only on the principal ballot insofar as.
OC and written test was conducted.
Yes. Now,
So
the question arose whether.
there is no No viva was in this case. No interviews being held. Yes.
Yes. No, my lord, I'm referring this judgment.
A legitimate expectation, Mr.
Yes, it's only on the ground of legitimate expectation.
So you think that we don't know what is legitimate expectation? Huh? What you at least you should have tell the page number. What do like?
My lord, paragraph 29, my lord, if your lordship can you take, my lord?
Yes.
A claim based on the doctrine of legitimate expectation arises when a claimant expects the public authority to follow a particular procedure before taking a decision. This is a contradiction to the doctrine of substantive legitimate expectation, where a claimant expects conferral of a substantive benefit based on the existing promise or practice of the public authority. The doctrine of substantive legitimate expectation has now been accepted as an integral part of both the common law as well as Indian jurisprudence. This part I'm referring to.
Right. So what is like, is your claim based on procedural substantive expectation or substantive? What is?
Substantive legislative expectation, substantive expectation on the part of the employees
Huh?
is valid insofar as with regard to phase 1 to 3 employees are concerned.
Huh?
The corporation ballot has allotted ballot.
No, no, also what, Mr. You have just read paragraph, so it is neither here nor there. You should tell us what is your claim is based on what procedural substantive expectation or what? Mr. He has disappeared.
There appears
You
to
are
be some
senior from the
issue.
digital this thing, right?
network issue.
Some issue, so we are unable. So what is it? Procedural substantive litigation, legitimate expectation or substantive legitimate expectation? What is the case?
He will take over because he has gone. Senior as
You, what to do? I mean, he is not there. So we are asking you, you should know. Ask him what is procedural substantive. Make use of technology. Ask him what should I tell the court. So he will tell you on WhatsApp.
Your lordship's permit
Procedure.
for a minute, sir. I will just go out and speak.
You're taking it seriously. Huh? Ask him.
No,
Well, as I told you the other day, I told you the other day that our sense of humor doesn't catch up very often. Well, it's
I don't know
obviously
under what
substantive.
question.
He's obviously pushing in substantive.
So what to do?
Para 43, your lordship may take up.
So?
Para 43.
No, so he has adopted the submissions made by senior counsels and then what next?
Para 43.
So then he has read 23 SCC online, that is Kerala Judicial Service, and then he has read para 29 procedural substantive. So then we are asking how does it apply to facts of the present case?
Yes, your lordship can take up para 43 minutes. Para 43 and 49. First, your lordship may kindly come to para 43. The principle of fairness in action requires that public authorities be held accountable for their representation. Since the state has profound impact on the lives of citizens, good administration requires public authorities to act in a predicable manner and the honor and the promises made or practices established unless there is a good reason not to do so. In Nadaraja Supra Law Journal held that public authority should objectively justify that there is an overriding public interest in denying a legitimate expectation. We are of the opinion that for a public authority to frustrate a claim of legitimate expectation, it must objectively demonstrate by placing relevant material before the court that its decision was in public interest.
So which paragraph of the petition pleading with regard to legitimate expectation? Your petition?
Yeah.
Which paragraph? A factual foundation has to be laid, right? Like you cannot argue anything. So tell us which para of the petition you had pleaded that on account of legitimate expectation you are entitled for allotment of land or plot or flat, whatever. Arey, mister, we are asking a question to you. There is not a place to play
No, I'm
games.
not-
You are doing like we are answering. We are asking you a question. You are this thing answering on mobile.
No, I'm not answering. Para 49, my senior has just taken.
No.
Milord, pleadings are there.
Which paragraph?
My difficulty is, Milord, the entire that physical.
File is with your senior.
Yes, he has taken. Milord, he is,
So will
he
you
is,
take
he is
this?
virtually logged in from AP. Milord, he is not in town. That's my difficulty.
What can be done?
Milord, may I request your lordships to
No, nothing.
just for tomorrow?
No.
There appears to be some issue.
What can be done?
Milord, he has just texted that there's some network.
You should have said in the beginning, right? You should have said in the beginning, I want adjournment.
No. Milord,
Nothing.
He is at one. Your lordship may kindly come to.
No, where is which paragraph is the mister in your petition? Where have you pleaded about doctrine of legitimate expectation? Tell us. Just like constitution bench judgment has come, so just finding it
Your
out.
lordships, but I'm just texting my senior as to.
No, nothing. That will
Only
not
just to assist.
assist the court. We are giving you our record to assist. We give him the case. Which case?
Item number 47, Mirror.
47. Give the file to him. Now, which paragraph? Where have you pleaded? What have you pleaded about legitimate expectation?
I'll take you now. Your lordship may kindly come to page 11, para 10. Page 11, para 10 of the appeal.
Page 11.
Para 10.
Appeal? No. Petition.
Yes.
Read petition. Which para?
Para 10, page 11, bottom.
Para 10 of the read petition. Which read petition?
In the appeal, yes.
Arey, mister, this is.
One.
This arises from an order passed by learned single judge, right? Appeal is not an original proceeding. So where is in the writ petition? You cannot argue whatever you feel like. So that's why. So please tell us where is what legitimate, substantive, procedural legitimate expectation, substantive legitimate expectation. Where have you pleaded? Yes.
Though we are adopting the arguments of the learned senior counsel now.
So there is no pleading of
No, there is pleading. Malat, the difficulty is
point out, you have our record. Which
Millet, 20 Millet of the judgment of the learned judge Millet.
page 20.
Yeah, Millet.
No,
Paragraph
no,
20.
Mister, we have asked the assistant a question. Where have you pleaded about legitimate expectation in the writ petition? Please answer that.
Millet, the learned
You
judge.
cannot, without pleading anything, you cannot argue at the time of final hearing of the appeal.
Millet,
Writ petition, which paragraph, whether it's a substantive legitimate expectation, procedural, you told that the distinction, Supreme Court said procedural is that, substantive is that, whatever it is defined, you have read it. So how does it apply to your case and where have you pleaded legitimate expectation? Which paragraph of the petition, that is the query.
Millet, your lordship kindly take Millet paragraph 20 Millet of the judgment of the learned single judge.
Judgment is, judgment is not pleading. How have you set up the case?
Because the contention Millet which was raised Millet before the learned single judge and which Millet the learned judge has considered it Millet, it is there in paragraph 20 of the judgment.
No, no, you don't have the copy of writ petition, that means.
No, I have pleaded Millet, your lordship can you take the affidavit?
Which, so tell us which para. What have you pleaded? Read it.
Millet, I have stated Millet insofar as with regard to not specifically Millet, if your lordship can you take Millet the paragraph 4 Millet of the affidavit. Para 4 Millet.
Please read because our copy is with your assistant. So we don't have anything. We are dependent. Read para 4, what is it?
Yes. Millet, I have said Millet, I submit that the members of the petitioner association have been appointed in the year 1981 and 1982.
Mr. I mean, we are surprised that the Lawrence single judge has allowed your petition. You are still arguing legitimate expectation and all that. The only question confined for examination is whether benefit of quashment should be given to all the members, even those who have not paid the amount in full. That is the question you are arguing as if your petition has been dismissed. What is legitimate expectation and all that? We don't know what.
Millet, in the affidavit Millet, I have also stated Millet with regard to the earlier allotment Millet which has
Your
been made.
petition has been dismissed by learned single judge.
No, but the learned single judge Millet has partly allowed Millet the writ petition Millet insofar as
That's what we are telling you, Mr. Counsel. The only question is whether benefit of quashment of order as by learned single judge has to be given to everybody. You are arguing as if your petition has been dismissed. It has been allowed, right?
Yes, it has
Benefit is only, so then what legitimate expectation and all that you are arguing before us? Doesn't understand these people.
Millet, the learned judge Millet has taken the view Millet for 217 members Millet it is valid. And directed Millet the government Millet to allow the house tax Millet insofar as 217 members are concerned. Millet, the communication problem Millet, this collection problem is there Millet. I'm not able to
No, we can hear you very clearly. I mean, the only query is your petition has been allowed. The relief is confined only. The only issue before us is whether the benefit should be given to everybody or it should be confined to 111 or 103 members.
Yes.
You are arguing on legitimate expectation. We don't know. How does it help?
No, because Millet, the state has also preferred, but the board has also preferred an appeal Millet against the order of the learned judge. For that Millet, I'm saying Millet.
Yes, go ahead, Mr. Say whatever. We can't prevent you.
Because,
Yes.
now, Millet, because already Millet, the other points have been urged Millet by the other senior councils. There's nothing more Millet to add Millet.
Thank you. That is all right. He has had nothing to add. All right. Yes. Who housing board? Who appears for housing board? Mr. Prasad, you are appearing.
State Millet, I have filed appeal
Now, what about this thing? Housing board has also filed an appeal.
Housing board has also.
Then who appears for housing board? So they are not interested in prosecuting their it's like, so in favor of employees.
Matter has also been assigned to the office of the AG. The housing board has also requested the AG to appear the matter.
Okay.
But since it's a common judgment, I thought by appeal filed the state, I will bring it to my lord's notice.
So state as well as you are arguing.
State and
housing board.
Yes.
All right.
But lordship will have to consider one basic factor, my lord. The land which was allotted to the petitioners was at a concessional price, not at the market value. It was a concessional price as a special case and a request made by the employees. It is not the market value which was collected by the state or the housing board. The one more aspect is what the original extent which was allotted under Geo 30, Geo 2 was only 13 acres of land. But it was subsequently, when it came to finalizing the issue of 320 people, the land was falling short by certain extent. Thereafter, another 13 acres were added, 26.541 acres were added. But this is to give all amenities to the persons who was being allotted with plots. Subsequent thereto, Geo 32 was issued. If your lordships kindly see Geo 32, cancelling the earlier allotment in pursuance to the cabinet decision taken in 2005, considering the requirements and urbanization of this city, but the benefit which was extended to the petitioners who have already paid the amount, 103 persons, was 20% interest would be paid to the amount which is already paid by the petitioner, and that would be adjusted towards the cost, construction cost of the flats. And no land cost was being collected, very clear. No land cost was being collected, only towards the flat. That to the amount which was collected by the state, 20% interest was added since there was a delay. But the rest of the 217 petitioners, as a matter of record, had not paid the amount, and also, it has been considered some have retired from service, some have passed away, some employees have passed away. But the first factor is the concessional price. Second, if your lordship sees at page 25 of the order, the lord's entire judgment of the lord single judge is based on legitimate expectation. The exception is overriding public interest. Overriding public interest in this case would be I have filed a counter in 525, Retail 525, item 47, page para 9, if your lordship sees my counter. I have taken a specific ground. 525.
Counter.
Page 74, minutes of Retail 525. Item 47, may I read? Page 74, your lordship. Para 9. As regards the allegation made in para 8 of the affidavit, it's submitted said allegations are incorrect and right. Further submitted in view of the changed requirements of the housing needs and in view of the fact that there is severe constraint of availability of land in the twin cities, it was felt that the housing needs of
One minute, Mr. Prasad. What? Yes.
Line 3, again, it is further submitted in view of the changed requirements of the housing needs and view of the fact that there is severe constraint availability of land in twin cities, are felt that the housing needs of more number of people can be met by making provisions by construction of flats rather than plots. Further submitted, there is no proposal to sell the plots to third parties. The housing board will utilize the land for the purpose of construction of flat. But this was the stand taken. Thereafter, then as regards the irrigation with paragraph submitted, there is a fundamental mistake in coming to the conclusion that only 30 acres of land would be involved by way of subject allotment. In fact, the total extent of land covered by subject allotment is around 26.54 acres. As such, a revised proposal was sent to the government. It is relevant to point out that here in 1988, That is on 29/7/88, the board in 391st meeting has resolved to recommend to government for according permission to allot the extent of 13 acres of land for allotment of plots to APHB, fixing the land cost at 5 per square yard. But this is the price, Malad, which I was pointing out. It's a concessional price given as special case to the parties. Thereafter, Malad, having
So what? I mean, we have got it, it's a concessional price. So what?
thereafter, Malad, since there is a delay on the part of the state, Malad, the state thought it fit, Malad, that more number of people can be benefited added by adding 13 more acres and also giving the 20% interest towards the amount.
See, Mr. Housing Board has framed a scheme. Housing Board has found that it is such a scheme for allotment of plots or flats, whatever, has to be framed for its employees. They have sent it to the government. Government has approved it. Now, so therefore, I mean, what is wrong with the order of the learned single judge, like in granting relief to them? What is fundamentally wrong? Please tell us.
The judge has proceeded on the ground of legitimate expectations, what my submission was. Overriding public interest, your lordship will have to consider in the specific case, Malad, here, where Malad, larger number of people are being benefited by the scheme now, which is a decision taken by the state. The subsequent GO which was issued cancelling the allotment and also advancing that the flats would be constructed without charging for the land.
No, what has now, see, 103 persons were held entitled by learned single judge.
Yes.
Have you implemented so far as 103 is concerned? No.
Status quo.
Status quo. Okay.
Now subsequent to this, after the, while the proceedings.
And but senior counsel told us that the land is intact, right?
Yes,
Whatever.
it's intact. I have got instruction intact. Now, Malad, if your lordship go
So now, what you want? What is your overriding public interest is not in allotting the lands to employees of housing board.
Instead of land, Malad, flats would be constructed for larger number of people. The same extent of land, lots individually being allotted. Malad, the state now the land being not available freely now. Is view the rapid urbanization.
No. So are you this thing? Are you willing to allot flats to everyone?
Yes, Malad. Kindly see, Malad.
At the rate of 204.
Rate, Malad.
Of course.
They have also agreed, Malad, the
Of course, 204. The development this thing apart.
but change in rate was accepted by the subject.
Flat means of same area. Flat of like what flat? It could be 2 BHK, 3 BHK, what?
That detail, I'll say.
Mr. Supposing if flat is allotted to you and they are willing to allot.
No, in fact, Malad, they wanted to flats be allotted at Hydernagar land, which we have, right to information we obtained. Hydernagar land has been sold. It is not with the housing board now.
No, but wherever you said no, that land is intact, right?
Yes, this land is intact, Malad. Where we Kukatpalli, Malad, where the land was supposed to be
intact. So like there you allot you flats at the rate initially agreed. I mean no alteration. That you have a right. What
no,
do you
Malad,
think of this?
plot is, Malad, with reference to the square yards and square feet, Malad, the basis how much square feet they would like to give. All that has not been spoken to. And in fact, Malad, your lordships may see.
So what is your first response to this? Like if they come up with some proposal of instead of allotting, they allot you flats, whatever dimension that we will of course.
With great respect, Malad, subject to what your lordship, it cannot be compared. Malad. Land is different.
Of course.
Land is different and built up area is different and how many floors they are going to construct and all this nothing, Malad. They should say, Malad, public interest, they should point out which has been spoken to in GO 32. But they can't now, Malad, in the counter improve. GO 32 only says.
No, we just wanted to hear first. Yes.
GO 32, Malad, I'll read it. GO
Which
32,
page?
Page 82.
Page?
82. My argument was one is the concessional rate, second, your lordship. Government after careful examination, may I read, Manoj? Proposal received in reference second and third read above from the Vice Chairman and Housing Commissioner AP. Housing Board hereby cancel the orders already issued in reference first read above. Government hereby permit the Vice Chairman Housing Commissioner AP Housing Board to construct and allot individual flats to 320 employees. But this was a query which had fallen from the bench, Manoj, of the AP Housing Board who were earlier allotted 115 MIG, middle income group,
181 lower income group, 24 economic welfare groups. The individual plots in the land situated in the southern side of fourth phase of Kukrapalli, Hyderabad to subject to following conditions. Permissions according to the Vice Chairman Housing Commissioner AP for the construction of individual flats for the employees appropriate to their category at the time of service will be allotted at current rates of construction without charging them the land cost. Interest at 20% per annum will be paid by the AP Housing Board on the amount paid by the employees initially towards the land cost, if any, which will be offset against the cost of the construction. The current rates to be changed to them. Approval of the AP Housing Board shall be obtained by the Vice Chairman and Housing Commissioner AP Housing Board. But this is what this GO 32, which cancels the earlier GO 6.
But it has been quashed.
Yes. That is
What
the reason
is-
I was bringing to my.
Mr. Prasad, you will have to tell us what is the overriding public
overriding-
interest which will even override their legitimate expectation.
But overriding public interest may not have set out in the counter. I have read it to my lords. But GO does. Fairly, but GO does not say. But in the counter, I have said so. But what is? But the lordship will also not have to take a judicial notice of the fact that urbanization, the state Kukatpalli is just very near to the city. It's actually within the city. But flats which are also being offered, they will not be costing pittance today. Flats which are being offered by the state today. But keeping in view the larger extent. First extent was only 13 acres.
No, but you must tell us before we can put them to this thing. You will have to tell us what is the public interest in cancelling, in not giving them the whatever initially.
But public interest, I would really submit. This is the public, the urbanization of the city, the growth in population, and the need.
Where have you said?
Counter.
Read it again. Counter para.
Para 9 minutes.
Severe constraint availability.
Yes. It's felt that housing needs of more number of people can be met by making provision by construction of flats rather than plots. This is the reasoning which is given.
But this is something like Mohinder Singh Gill, not saying in the order and supplying this thing subsequently by.
Otherwise,
I don't know.
Otherwise, then if the lordships consider the aspect which is matter of record and not disputed is 13 acres land being increased to 26 acres for providing them with all amenities, roads, spaces, kindly see note, I have said so in the counter also, for providing all amenities, leading for a properly layout colony, so properly forming a layout. Extent has also been increased by the state from 13 to 26 acres. Earlier,
No, but see, who is responsible for delay in implementation of that scheme?
my humble submission would be the interest part.
It will hinge upon that, like the answer to some extent will also, who is responsible?
But may I submit this, if you for your lordship's consideration. Interest part which is being paid and land cost not being collected. Two factors if your lordship consider. Now only construction cost is what is being paid. Land cost is not being collected from the petitioners. But this will go to the root merit because for the reason that concessional allotment in terms of land cost not being collected. It will be again a concessional construction at the concessional rate. This petitioner would be benefited by the construction of flat by the housing board or the government, and the price would be very less compared to the market.
This is the geo which has been struck down by the learned single judge.
Right.
You will have to meet the reasonings why. I mean, you are banking upon that very geo, but it has been the fact is petitions have succeeded.
Yes.
So why you please tell us why and how the order is bad. Why it should.
Apart from this period, I have submitted before my lords saying that larger public interest and 20% interest and also flats being constructed without collecting land cost. But state largest, your lordship will have to consider the land not belonging to the state.
No, but you have agreed, Mr. Merely you can't go back because the prices of immobile properties have gone up astronomically. That's why you can't back out.
Your lordship,
There has to be some, see, Mr. There has to be some justification, some plausible explanation as to why, like, why learned single judge was quashed, no?
But kindly.
Doctrine of legitimate expectation can be superseded or defeated in overriding public interest accepted as a proposition. But what is that public interest?
Public interest is serving more.
No, but you don't say so, right? Again, then Mohinder Singh Gill, then again, that you don't say, Geo, you in the order you don't say. It's on. If you would have said that these are circumstances 1, 2, 3, 4, 5, and therefore we are now instead of. So you are arguing virtually on the Geo which has been quashed, right? You have to first meet the reasonings why it is bad.
That's one more aspect which I like to bring to my lord's notes. Page 25 of the judgment.
And one thing, Mr. Prasad, you will have to meet apart from this. Why supposing if we don't agree with your submissions, what is the reason, what is the justification of confining it only to 103 and denying it to remaining people?
But the finding in the record also says 217 people have not paid the amount.
Not paid means, but you have asked them not to pay.
Much later stage. The lordship consider that has been considered by the learned judge, of course, and before my lord's not kindly see the reasoning which is given by this.
Which para?
But may I just read one page 25, your lordship, page 25. I just wanted to rely on one of the GOs, which was actually the basis for the issuing of that GO issued by the state. Page 25. But this is one of the GOs, I'll just ask before my lords.
No, what? This page 25 is something.
The learned judges, running page 25, learned judge's judgment.
Para 12, 13.
Para 13. Kindly go to next page. Top.
Yes.
Council of Ministers approved the report of subcommittee on 1/4/2005 for registration of 320 plots.
No, where?
Last line of page 24.
Subcommittee on 1/4 for registration.
320 plots allotted to the employees AP Housing Board subject to conditions stipulated in GMS 24/2244. Revenue Assignment 1, Department dated 28/2/2005. It's also an undisputed fact after cabinet resolution, government have asked the Vice Chairman Housing Commissioner to submit necessary proposal incorporating conditions. But these are the conditions which are forming part of GMS 22/244 dated 28/2/2005, but which envisages how the lands belonging to the state has to be dealt with. The conditions of allotment. This was incorporated, that is how the GO 32 came to be issued. But thereafter, if your lordships consider, then line about 10 from the bottom, the matter was brought, if your lordship, the matter was brought to the notice of the Board of Consideration. The matter was discussed. Board resolved to allot 26.541 acres of land under Phase 4 of AP Housing Board, 13.66 acre plotted area, plus 12.881 acres for roads, open space, community purpose. But that's what I'm saying. The extent also increased from the original allotment to the next. Extent also increased. It was not there to 26 acres was not subject matter of the earlier first allotment made. Next, if your lordship go next page, recording of fact, next page. Next page. When the matter stood thus, the Vice Chairman Housing Commissioner AP Housing Board have submitted the revised proposal during December 2005, request to cancel all the allotments to provide houses at concessional rate without charging for the land value in the proposed other scheme for the following reasons. And only 102 people have paid the full amount asked for, and 217 people have not paid the full amount asked for. GO referred to in the cabinet decision relates to the payment of market value as per the basic value, as per the basic value, what has been collected from these employees are in nature of only a fraction of market value, such as ₹5 against the market value of 180. Several people have bought by way of either concessional allotment or outright purchase flat. 12 people have retired in meantime, dead, and some have been removed from service. All these factors were considered before. To give semblance of fairness, we have sent proposal to administration, but it appears it's quite different.
We'll continue tomorrow. Mark the presence, learned.
I seek indulgence of your lordships, my lord, to join virtually, my lord, tomorrow.
Yes.
Obliged.
Learned senior counsel for the petitioners have concluded. Today also. This one.